Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-3035 et al. United States of America versus Brittany Jones, also known as Brittany Elise Nancy Jones, appellant. Mr. Jones for appellant Brittany Jones, Ms. Millian for appellant Willis Lewis, Mr. Goodhand for the appellee.
Good morning, counsel. Mr. Jones, please proceed when you're ready.
Thank you. Good morning. May it please the court. I'm Antone Jones, and I represent Brittany Jones, the appellant in this particular case. This case focuses on several issues. One of the issues that we're more concerned about is the variance in the indictment. As the court is aware from reading pleadings that in this case, there was an allegation, well, there was a jury returned a verdict in which my client was found guilty of a conspiracy. Conspiracy and indictment alleged have taken place on April the 19th, April the 25th through May the 19th. The evidence in the case showed that Ms. Jones was, assuming argument she was involved in the conspiracy at all. Her involvement took place at a shorter period of time. Her involvement only included April the 26th and April the 27th. In that particular time, our position is that there were multiple conspiracies here. What happened was Ms. Jones is alleged to have met the two victims in this particular case on April the 26th and ended her involvement with them on April the 27th when she was physically threatened and forced or banished from the enterprise. At that particular time, there was uncertainty as what was going to take place, although the overwhelming indication was that there was going to be some sort of sexual trafficking or maybe even strip parties, but the two people involved, the two victims involved were going to be involved in that. However, there was an incident in which Brittany Jones was instructed to transport the individuals to a location and nothing took place at that particular location. Because of that, Brittany Jones was banished from the organization. After that, what happened was that the individuals were transported to a hotel. In that hotel, there were sexual acts that were performed for customers. Brittany Jones wasn't there. She wasn't involved. She had been banished from the group. All that evidence came out in trial. Next, what came out is after that first stint at the hotel, there was another stint at the hotel. And then subsequent to that, the individuals left or escaped. And that was approximately May 11th when that transpired. Now, our position is all the evidence came through at trial, talking about what happened at the hotels, who was involved in it. And our position is that's a variance in the conspiracies here. There was one conspiracy in which Brittany Jones may allegedly been involved in, but a separate conspiracy in which she was banished outside of it. And that's what transpired here.
Am I right, though, that the record shows that Ms. Jones had ZS and THY there as, I think she said, girls who wanted to work. And she's the one who, when the work at the one person's house didn't turn out, contacted Mr. Lewis about getting work for them. And then drove them to Mr. Lewis. And then actually, after that contact with Mr. Lewis, drove them to another location where they were supposed to have this commercial work performed. And it was only after that fell through that she separated for Mr. Lewis, but she actually was the one who took the girls to him, told him they wanted to do this type of work, and made an effort at that first opportunity.
Yes,
Am
but
I reading the facts correctly?
Yes, I would agree, but there's something to add to that.
Okay.
Yes, she did come in contact with him, met with Mr. Lewis, and they were supposed to do something at the residence involving where Mr. Lewis was at, and that didn't work out. Then there was a customer that was supposed to meet them and meet one of the young ladies at Greenbelt. They called Miss Jones to take them there. She went there. She didn't like how the situation was. That didn't work out. They came back and she explained that
Back
to
to
him.
Mr. Lewis.
Right.
Brought them back to
Who-
Mr. Lewis a
Who
second time.
became upset
Mhm.
that it didn't work out and that Brittany Jones was
No,
one
I
of the
under-
reasons.
I understand that she's upset and then she's like, okay,
Right.
goodbye. But she, even if we assume there were two stages, it's conspiracy, she was the bridge that brought ZS and THY to Mr. Lewis. Informed Mr. Lewis that they were looking for commercial sex work. And made a first run out to Greenbelt with them. That went, felt, she made a judgment call, brought them back to Mr. Lewis. So at a bare minimum, she was, even if we assume sort of again, two series of events, she was the bridge between the two, and she's the one who maybe performed most significant act in instigating the sexual mistreatment of these girls by bringing them to Mr. Lewis and telling him what he could do with them.
Well, it's unclear whether they were going to have commercial sexual acts at first when she brought in Mr. Lewis, or they were going to be involved in,
She told him they were looking for work.
right, which
What kind of work?
also could involve striptease, because they were talking about having, they were talking about stripping as well. Yeah. So that it was unclear exactly what. However, I must agree that going to Greenbelt, there was going to be some, at least there was a thought of commercial sexual activity. However, there was no indication of all of them staying in a hotel, having people come to the hotel. All that happened next. That's a totally different enterprise, which she was banished from. And given that overlap had nothing to do with Brittany Jones, and that's where the variances and the conspiracies are saying, because it became a different operation, a different term. It's almost as if you and I were going to be involved as partners in the business. You bring the supplies to the business. You purchase, take care of the supplies. I'm the marketing person, or something to speak. You don't like the way my marketing is going. You terminate the marketing. You get someone else, you do some other marketing. I don't get money. I'm not involved in your enterprise anymore, just like Ms. Jones wasn't involved in the enterprise that Mr. Lewis subsequently took.
So, Mr. Jones, conspiracy law tends to be very broad. It's very encompassing of a lot of different time periods and events and people. You know, it seems to me that you're asking us to make new law here that will make conspiracy harder to prove, this is not consistent with my understanding of how conspiracy law works. Because, sometimes we see cases with, drug conspiracies that lasted 20 years, and some people come in and out of the conspiracy, and some people were in it just for the first 5 years. It's still one conspiracy. I just don't see how your theory fits in with general conspiracy law.
Well, she was forced out, and it's almost a withdrawal. This is withdrawal before that.
You didn't argue withdrawal, but also withdrawal is a very high standard.
No, I understand, but she was banished out of the conspiracy at that particular time. If there were a
So
conspiracy,
you're asking us to make a ruling that in conspiracy law generally, if somebody is banished or forced out, they're not part of the conspiracy, even though they were in it to begin with? I just don't understand what you're asking for here and what that would do to our law about conspiracy generally.
well, the facts here would indicate that there's no dispute she was banished, she was put out, she was forced out. There's no dispute with respect to that.
I'm just saying that I don't think that's an uncommon thing, like just in the in the world of conspiracies, there's so many of them. They last for a long time. People come in and out of them all the time. And I don't think we've ever held that, under these circumstances, you're not in the conspiracy, or you're not liable for part of the conspiracy you were there for.
Which, and I may be liable for the part of the conspiracy you're here for, but in this particular case, it's clear that the conspiracy had evolved or had changed here from.
That's what I'm saying. I just don't think that that's unusual. I think a lot of conspiracies evolve over time. Some of them last decades.
I understand that, but the fact scenario here is somewhat different in the sense that we're not talking about a drug case or something along those lines. We're talking about.
But our holding would apply to all conspiracies.
No.
Whatever you ask us to hold, it's going to apply to all conspiracies. And I just don't see how this fits.
Well, it would seem that it would be appropriate, given the fact that Brittany Jones had nothing to do with anything with respect to the hotel situation. That could have been addressed with respect for the proper jury instruction, indicating that.
But that's not how conspiracy law works, is it? I mean, there's an overarching goal that everybody is involved in, the trafficking of these minors, and your client's role was soliciting them, bringing them, transporting them, and then she wasn't there for the hotel part, but that doesn't mean she wasn't part of the conspiracy and promoting its overarching goal.
It would have been different because in this particular case, she was supposed to be part of the conspiracy and supposed to receive some of the proceeds. At least that's what the testimony was. In this particular case, it's clear that she wasn't supposed to receive any of the proceeds involving the hotel or being involved in anything involved in the hotel at all. And that's one thing that's a bit different because we know she was not supposed to be involved in that separate conspiracy. And that's what we was, that's what we say. That's clearly the separate conspiracy. And it's clearly variance in this particular case with respect to that particular conspiracy. And we believe all the evidence generated on that is extremely prejudicial to Ms. Jones.
Make sure my colleagues don't have additional questions for you. Thank you. We'll give you a little bit of time for rebuttal. We're having a clock malfunction. So we up here can look at that clock, and then Ms. Rothenberg, can you give the council the iPad? We'll put an iPad up at the lectern so you can see the time remaining for additional councils today.
All right, thank you.
Thank you. Thanks, Eve. Ms. Millian.
May it please the court. Good morning, Your Honors. Courtney Million on behalf of Mr. Lewis. I'd like to reserve 2 minutes for rebuttal. Mr. Lewis received a fundamentally unfair trial and sentence. It was fundamentally unfair because the district court made replete evidentiary errors, one of which the government admits to, that combined create a prejudicial error requiring reversal. It gave a plainly erroneous jury instruction, and it abdicated its fundamental responsibility at sentencing to make fact findings in support of its guideline determinations and to offer a reasoned basis for its decision, particularly in the face of an express objection from defense counsel. I'd like to start with the trial errors, but I, of course, welcome questions on all issues. I would like to begin with the district court's Rule 16 error. The district court forbade defense counsel from cross-examining 2 of the government's important witnesses about statements made in jail phone calls because the district court erroneously believed that those had been improperly withheld under defense counsel's reciprocal discovery obligation. The government admits that this is error.
How do we know how the defense was prejudiced by that? Because no record was made as to what the cross-examination would have been.
So a couple of responses to that. The burden is on the government to show harmlessness. The burden is not on defense counsel.
There's just nothing in the record, though, to show what the harm was, because we don't know what that cross-examination would have been.
First of all, I'm not sure that's the case, but
So what would the cross-examination have been, and where is that in the record?
so we don't have a specific discussion of what the cross-examination of those particular witnesses would have been, because that information,
Isn't that necessary to know what the harm was from this error?
I mean, to the extent it's necessary to know what the harm was, the government fails to prove harmlessness. But
Regardless of the burden, I just don't see anything in the record that allows us to evaluate the harmlessness or not.
so a couple of points on where I think we can understand where the harm comes from. First, the government fought tooth and nail to keep this evidence out. It filed reconsideration
Not
motions.
what the analysis is it? It has to show how the trial would have been different if this cross-examination had taken place. And it's kind of the job of the defense attorney to make a record and say, Your Honor, this is what we want to cross-examine about. Sometime during the course of, or even after the witness is done, like, you have to make a record, or else we can't evaluate how this affected the trial. We just don't know. It's not there. We don't know what this cross-examination would have been.
So, I mean, obviously, ideally, I wish a proffer had been made. I think that would make things simpler for everyone here.
How do we do this? You're saying we can still do it. It's just not as simple. I just don't see how we can evaluate this. And it can't be just based on how hard they fought. Like, that doesn't show harmless error.
So I didn't finish my answer on
Okay, go ahead.
what is in the record. So I want to make a couple of points on this. First of all, I think we can understand harmlessness in part because or the absence of harmlessness here, in part because we have evidence of what happened when those jail calls were used with other witnesses. And we discuss at length in our briefing what happened with Taylor and the way that evidence was powerfully used to impeach her. The fact that she wanted her phone hidden, the fact that she was talking with her father about engaging. I mean, the defense at trial was that it's Taylor's fault rather than.
Doesn't it have to be tailored to the testimony of the witness that you wanted to impeach? Like, just saying that this same evidence was very effective in impeaching some other witness who had different testimony doesn't tell me how you would have used it with respect to the ones that you're saying there was error with respect to.
I mean, I don't think that the case law says you cannot ever look at what was introduced and how evidence was used effectively.
But I still don't understand, like, how your client was prejudiced by not being able to use those jail calls to impeach the particular witnesses that you're saying. Where
I mean, to the extent we don't know precisely how it would have been used. I realize I'm repeating myself here, but I think that's the government's problem because it's their burden to prove harmlessness. The reason this is not in the record is because they fought tooth and nail to keep it out.
What if they prove harmlessness by saying it's just not in the record and we don't know what the harm is? I just don't think this is a burden issue. I think this is a gap in the record issue.
I mean, it sounds like we disagree on this point, and you're obviously the judge here, but I would also just note that in this dialogue, I mean, the district court was extremely angry and incorrect in its assessment.
If I agree with you that there was error here, I still have to assess harmlessness. That's kind of what I'm trying to focus on.
I just want to finish the point quickly. The court cut off defense counsel and said, bring in the jury. There was, I think, to the extent there's fault in a record not being made, it falls with the district court.
We've got very experienced defense counsel here. And after the witness testifies, what they should have done, which I think you agree, is, Your Honor, I just want to make a record on your exclusion of the jail calls. And I just want to say, this is what they would have shown. That's what should have happened.
I still think this is reversible error given where the burden falls, but I understand that Your Honor obviously doesn't agree with me on that point.
Do you have a case or cases that establish that proposition that in this kind of situation, because of where the burden lies, the absence of a record falls to the detriment of the government?
I don't have a particular case, but I think it follows from like intuitive first principles. And I've not seen a case where, a court has said you can't establish harm based on how this evidence was used. with respect to different witnesses, nor that if it's not in the record, the defendant necessarily loses because of this burden issue. I have not seen that particular.
Well, I mean, I take the point on the use of the evidence for another person, because in theory, if that evidence directly applied, I mean, there's no reason not to use it. I understand that, but there's a separate question about whether you project evidence that's targeted at somebody else to this scenario. But on the initial question of whether in a circumstance in which there's an arguable error, but there's a question about harmlessness, and there was no record made through a proffer or anything like that, that it's on the government that they can't prove. I totally understand the legal point that the consequence of that error falls on the government when the burden is on them to establish harmlessness. But in a circumstance in which there hasn't been a record developed by the defense or a request to make that record that was denied, I'm just wondering whether we have law that tells us what we do in that situation.
I don't have a specific case to say to you.
What do we take? You haven't raised an ineffective assistance of counsel claim for failure to make the proffer, although I think kind of, as you said, ideally that would have been done here. It would have made at least our analysis much easier if the absence of the proffer were materially prejudicial in a Strickland sense. Then wouldn't you have made an ineffective assistance of counsel claim here?
I work for the federal public defender. The lawyers below were members of the federal public defender's office. I cannot make that argument. There's a conflict there.
Can you address the sentencing here? I do think it's problematic the way the sentencing proceeded. And I guess there's a number of sentencing errors that you've asserted. If we think that there's an overarching problem with the failure to make findings and address specific arguments, is that just kind of a global remand, or do we need to address every issue that you've raised?
I think, first of all, I think a global remand would be appropriate here. I do think, particularly on the vulnerable victim enhancement, we've made a clear argument that on this record it just could not be sustained. So I think it would be.
I was wondering about that. Is that something that we should decide, or should the district court decide in the first instance? Because the district court never said which theory it was relying on in applying that.
So, I mean, I think ultimately that is to Your Honor's discretion. We would obviously encourage, and I think clarity would be appreciated on like what the appropriate test is for the vulnerable victim enhancement. I think, we're likely to end up back here if there isn't some clarity on that particular question, which, there's case law in the circuit saying, it's an open question how we should understand the vulnerable victim enhancement. But I do think, the court can offer that clarity, or can, quite frankly, it's within its discretion and how it resolves its case to sort of
What is the right test? I find this courts are all over the place. I find it rather difficult to wrestle with. So what is the right test for defining whether someone's a vulnerable victim, at least in a context like this, where you're dealing with sexual abuse of minors, where everyone is almost inherently vulnerable because they are minors abused by older people? What is the right test?
The right test is someone vulnerable relative to a typical victim of the offense?
How do we decide who a typical victim of an offense like this is?
One is case law. I mean, there's considerable case law on youth, on poverty, on, disassociation from family and friends, remoteness, being the kind of things that are tragically prototypical of victims of sex trafficking.
These are also tragically prototypical of what it means to be vulnerable to this crime.
True, but I think that feeds into the point that this is, what animated Congress to make this a crime, and a crime with such a severe guidelines range. I mean, we're talking about life here. Mm-hmm. The idea that people are vulnerable people are preyed upon is baked into the guideline here. And, given the discussion in the guidelines commentary about how if it's incorporated into the offense guideline and, the example with the bank teller, that indicates that the type of test we're talking about here is vulnerable relative to the offense of conviction. And to the extent the court's
I have some
concerned.
concerns with this theory, counsel, because it just seems to me that the bank teller analogy is, if that guideline is about bank robbery, you don't get an enhancement because it's a bank teller. It seems to me the correct way to apply that to this situation is it's a minor, so you don't get to be considered unusually vulnerable because you're a minor. But that doesn't address being a runaway, being from foster care, being homeless, being drug addicted, being mentally. It just seems to me troubling as I was reading some of the cases that were being cited that we're going to say that people who are homeless and from foster care, and some of them are 12 years old, are not unusually vulnerable because as a class, they all are unusually vulnerable. I just think that's really difficult to apply. I find that really troubling.
I guess I would say, to the extent the court is concerned that, these sentences are not going to be high in sex trafficking cases when vulnerable people are being preyed upon. The guidelines, again, are exceptionally high here. So I just don't think that one needs the vulnerable victim enhancement to capture this type of concern.
I think I also have sort of a logistical issue, which is the trial judge then has to make a finding in each of these cases what the typical vulnerable victim is. And are the parties going to brief that? Like how?
So as I said, I think it can be resolved based on case law. But if Your Honor doesn't think it can be,
so you're going to submit a brief to the sentencing court that says, based on this case law, or I guess you would need statistics or something. Typical victims of trafficking have these characteristics. I just think there's a difficult logistical fact finding issue as well that would be incorporated into this theory.
I think so. As I've said, I'm not so sure it's that difficult given that you can rely on case law. But setting that aside, I think sentencings are difficult. We have very complicated questions sometimes, and like apportioning loss and things like that district courts are required to engage in that involve statistics and numbers and things like that. And, I just think
in each case you would have to say runaways, X percentage of trafficking victims are runaways.
I think that would be one way to do that. I don't think the case law
X percentage of trafficking victims are homeless. It just seems, I think this is hard. I don't even know if those statistics exist. I think this is difficult.
The fact that it's difficult doesn't mean that it's not the right test.
No, I agree. But I'm just saying this whole thing troubles me, both logistically and analytically, just for courts to be making factual findings that a homeless, penniless runaway who's been through foster care and is desperate is not unusually vulnerable is hard for me to swallow.
And I would also sort of, in response to that, I would also note the district court also just didn't make fact findings about what Mr. Lewis knew or should have known.
We're just talking about the proper test here, and I'm having trouble with it.
Yeah. And perhaps that counsels in favor of just sort of a broader remand where these issues can be more sort of fully
Is your idea
ventilated.
of the way that this should work? We have the option of, if there was error, to remand without setting the law on this and allowing for some further development. But is your idea of the way that this should work is it's actually just about majority, non-majority? So it would have to be a situation in which the circumstances of the particular victim are unusual in that they're less than 50%. And I know we can always do the percentage game where we say, exactly what percent. That's not what I'm trying to do. I'm just trying to know, what's your idea of the overarching standard? Would it be that the circumstances of the particular victim are unusual in that if you combine all the circumstances, less than a majority of the victims of this particular offense will have those characteristics?
So I don't think it's quite that, because you could be unusually unvulnerable. Like, it could be that it's not this particular assortment of characteristics of someone are like not typical, but that assortment of characteristics actually makes them less vulnerable than the typical victim. So I don't think it's just like identifying characteristics and then saying, do most people have these or not? I think one needs to, and I don't have a fully fledged out answer, because candidly, I'm personally satisfied by the case law, the way the case law has resolved this, because I think, sometimes we have great precision in sentencing, but oftentimes it is a bit of a gut instinct. And, often I would wish there would be a lot more precision in how we do this kind of stuff. And courts say, no.
But what is the gut instinct? I don't deny any of that, but what is the gut instinct towards? What would we expect the judge to have a gut instinct by reference to?
The idea that someone who is like in poverty or doesn't have resources or is young are the kinds of things that are typical of victims of sex trafficking. And, in this case, we have testimony from an expert that these are the kind of adversities that she sees all the time in her practice. So I think this is, there is stuff in the record about this as well.
But I mean, people who are not young are also victims of sex trafficking.
True, but the guideline here is based on the idea that, the only reason we're applying 2G 1.3 is because the victims here are minors.
Right, but I'm trying to determine whether it's unusual or atypical or...
Well, it is not unusual of sex trafficking of minors for someone to be a minor.
If you use that as the baseline.
Yes.
Hmm.
And that baseline comes from the guidelines. That comes from the fact that 2G 1.3, which is the guideline they're sentenced under, only applies if it's sex trafficking of a minor.
Do you have a case or a circumstance where someone was found to be a vulnerable victim under the sentencing guideline that you think was appropriate, that didn't involve reference to common criteria? I'm struggling to figure out what would make someone vulnerable.
So I think what would make someone vulnerable.
Are there any? There's no cases.
So we cite a case out of the 10th Circuit. I want to say it's called Smith, but it's in the briefing, where the victim in that case was found unusually vulnerable because she was found to be like unusually sort of like small and weak relative to other minors.
Physically small and weak.
Yes. I don't find that especially satisfying, but that at least like begins to engage with the proper analysis and is certainly not something found here. To me, a better example would be, and I don't have a specific case, but I'm not saying it doesn't exist, or like if someone was handicapped and that's why they were trafficked. I feel pretty comfortable saying that is someone who is unusually vulnerable by virtue of, their handicap.
Can somebody be unusually vulnerable based on the combination of factors, that they're a runaway as well as penniless, as well as from foster care, as well as drug addicted, as opposed to looking at each one separately? I think probably yes. But I don't want to get ahead of myself, given that, this is going to end up getting litigated below. I think that makes sense, but I think the factors identified here are ones the case law say doesn't make you unusually vulnerable. They're talking about. I'm just asking if these factors in combination.
I would not say that
come up with it.
These particular, whether a particular set of factors that exist might.
I guess the question is, just to follow up on Judge Fan, I guess the question is if you could have several factors that in and of themselves wouldn't be atypical, and take age out of it, because even if you take age as the baseline because of the way this guideline is framed, but these other factors, they might individually be more typical than not, but to have multiple of them in the same one, you could do probabilities, and 0.51 times 0.51 is something around 0.25. And so if you layer multiple of them together, then you might be in an unusual situation, whereas you wouldn't be if you just took each one of them as independent. So it seems like you'd have to be able to take into account multiple considerations in combination.
I think that makes sense to me. And I suspect, I mean, I don't want to keep returning to the idea of needing a mushy test, but I would have a very hard time arguing that that was like reversible error and a misapplication of the test if that's what the district court had done here.
To take them into account in combination.
Yes.
Did you want to talk about the reckless disregard instruction? Or if my colleagues are, I'm sorry. You done it?
On this, yeah.
The district court used at least a paraphrase of an instruction that had been given in other contexts. There doesn't seem to be any settled law. So on what basis could we find clear error?
So I think a couple of responses to that. I think this is more than a paraphrase. First, I think it's more than a paraphrase of the instruction. And I do think the law is settled enough for the court to find plain error. On the paraphrase of the instruction, there's a very important difference between the instruction that is in Sand and the instruction that the district court gave. And that is that the instruction in Sand at the end of it references the coercion of a minor, that the minor was coerced. And this just repeats the phrase, the fact, the fact, the fact. And if you read it, I think the only fair reading of it is that the court has essentially said that you don't need to be aware of the facts from which one would draw an inference, because it just keeps repeating the term fact. And I think the law is at the very least settled on the idea that you need to be aware of the facts from which one would draw an inference of that there's a risk of coercion. But that's not the instruction given here, given the way the fact is repeated. And when we, interpret a repeated word used throughout something like a statute or an instruction or anything, we tend to think it refers to the same thing.
What about the fact that he said high rather than highest probability? Is that material?
I'm sorry, say that
It
again.
just required them to indicates a high probability of the fact at issue. Taking your points about the fact at issue, but the modern, the Sand instruction required a finding that the highest probability.
I mean, that is obviously a problem as well, because it's lowering the standard on, one's knowledge of the fact or appreciation of the fact.
We're on plain error review though, aren't we?
Yes.
So you have to show plain, clear and obvious error. So even if you're right, it has to be something more. And is it even plain? Like, is this something that we've already decided?
So we don't have a specific case that has decided under this statute the meaning of recklessness. I cite a case called Woodhall.
But is that fatal to your argument though on plain?
I don't think it's fatal. I think case law is clear that if it's, you don't need a case directly on point if a norm is well established or if you have
obvious. And if you've got one out of circuit case, does that
that's
make
an
it
in-circuit
plain, clear and
case.
obvious?
It's an in-circuit case, and it's interpreting the meaning of recklessness to require subjective knowledge of the risk. And in particular, it's in a statute that it's whether you're reckless as to whether a 1512 offense is being committed. So it is, it's not a statute that is 1591. The sex trafficking statute at issue here. It's not a case about where they're interpreting the exact statute at issue here, but it is a statute that makes reference to it. It is very, very close to this case, and it's interpreting it to require subjective intent. Or subjective awareness of the risk.
Could I ask on this issue, for the other prongs of plain error analysis, when you get further down the line, what's the theory under which the reckless disregard would have been the way in which the jury would have found Lewis guilty of these offenses, as opposed to something more than reckless disregard, because he was the one who was alleged to have used the force and coercion? And we have separate issues about whether there were evidentiary errors that allowed the jury to find that element. But if we just assume those away for present purpose, and I do have a question about those, but if we assume those away for present purposes, then what's the theory under which the reckless disregard part of the statute comes into play on the facts of this case?
So the government's theory is that Mr. Lewis knew about the coercion and was doing it himself. But the defense's theory is that's not true, that Taylor was the one engaging in all of this. And so I think the jury could well have convicted Mr. Lewis on the idea that he, a lower standard of reckless disregard that allowed for an objective appreciation of a risk rather than a subjective appreciation, given that the defense's theory was that it's Taylor was the one doing this and Mr. Lewis was off to the sidelines. And I want to apologize, but I really need to grab my water.
Sure. And then for purposes of the plain error standard, the fact that the defense has the theory, I get that the defense has the theory, but in terms of whether the subsequent parts of the plain error standard are satisfied, and take your time, I don't want to.
I'm sorry. Please finish what you're saying, and I can hear if I can't, even if I can't speak.
Sure, absolutely. How do we factor in that the defense? Yes, the defense has that theory, but in order to determine whether the subsequent prongs of plain error are satisfied, I don't think we take the defense's theory as a given.
I don't think we do, but we cite case law about the idea that when there's conflicting evidence on a particular point, that can make the plain error standard a review on third and fourth prong. And here, the government argues about Mr. Lewis knowing and cites, its particular parts of the record for the proposition. And, in our briefing, we go through and cite, conflicting parts of the record. And I think when you have that conflicting evidence under the case law that we've cited, it's, remand is appropriate here.
And I have one question about an antecedent point, and that's just about your argument about the gun, not the gang part of it, but the gun part of it.
Yes.
With Manns. So even if we assume that there was an error under 40443 in admitting that evidence, the government makes a harmlessness argument.
Yes.
What's your response to the harmlessness argument? And I take the point that the burden is on the government, but what's your best argument that the government has not satisfied its burden?
I think when a jury hears evidence like someone held a gun to my head and threatened me, someone's wife who they have a consistent relationship with, I think that is a bell that just does not get unrung here. I mean, that is like devastating, horrific information that if I was sitting on the jury, I would think, not because of guilt or innocence in this case, but this is a dangerous man who needs to be locked up. And I just think something as graphic and horrific as that is the kind of thing that demonstrates error, particularly when you have things here like there was no instruction about the proper use of this evidence given at the time. We're talking about cumulative errors here. We've obviously alleged additional errors, and including the fact that the defense was not allowed to cross-examine Ms. Manns with the jury, with the jail calls. I think that establishes the harm.
But it can't. If there were a lot of other evidence of force, coercion, et cetera, then I don't know that the law is that if there's one particularly graphic one, that it's necessarily non-harmless.
I mean, I think in the 404B context, the law sometimes does reverse, and we cite cases where there was cross-examination or it was brought out that domestic violence was committed, and independent from whether there was some evidence of guilt. I mean, this was a very hard-fought case, and the government brought out its witnesses. Its star witness was Taylor, and the defense did an exceptional job of impeaching her reliability. And often, particularly today, you have more neutral evidence that is not a witness testimony demonstrating guilt here, but the government and there are text messages and cell site and all of that. But this is a case where Taylor herself has admitted she was constantly using Mr. Lewis's phone. So that type of objective evidence just is not powerful in the way it would normally be in a case. I think this is a very close case. And I think in that context, hearing about something as horrifying as holding a gun to your wife's head because of some dispute, I mean, I don't see how a jury would properly put that out of their mind and not draw the just incredibly overwhelming inference that this man needs to be locked up because he's a threat to his wife and women more generally.
Yeah, let me make sure my colleagues don't have additional questions next time. Okay, thank you, Ms. Millett. We'll give you a little time for rebuttal. Mr. Goodan.
Morning, Your Honors. May it please the court, David Goodhand of the United States. With the court's permission, I'd like to take the issues raised by my opponent in the same order that were raised just now, starting very briefly first with the variance. Much of this has been discussed in our brief, but most fundamentally, this notion of two separate conspiracies, I think, is belied by the fact that Lewis and Jones, put simply, worked together to traffic the minors. Jones was instrumental in getting the victims to Mr. Lewis. And, this notion that she exited the conspiracy early because of the banishment, well, in the narcotics context, a supplier could provide 3 kilos of cocaine and then step out of the conspiracy. So I don't think that answers the question. Turning next to the
banished.
I'm sorry.
Do you agree she was banished?
It certainly seems like the tenor of the interaction on that April day was such that Lewis was unhappy with her. I think it wasn't necessarily Lewis who banished her, but Taylor took her aside and said something to the effect of, "You need to make yourself scarce or we'll both end up dead." But there definitely seems to...
On April 27th.
I'm sorry?
On April 27th, during the conspiracy,
Yes.
Mr. Lewis emailed a copy of his loyalty contract to Miss Jones. So
Yes.
it seems like, at least in Mr. Lewis's eyes, she was not banished.
Yes.
He just needed to be cooling down for a couple of days.
Possibly, certainly seemed to suggest that...
Surprised you would agree with the banishment characterization, given that there was a later contact between the two of them related to this process.
I think inferences can be drawn on either side. My point simply is that it's irrelevant to the ultimate decision in terms of variance. With respect to the gun and the issue of harmlessness, as we've articulated, we think there are a couple routes for permissible admission of the gun. First, it was direct evidence of the felon in possession. Second, we do think it related.
Hang on, did you argue those as the basis for admission to the district court?
Well, certainly there was
The government.
I'm sorry.
Did the government argue those?
Well, my opponent has conceded it's relevant direct evidence.
I mean, this is a discretionary judgment whether something comes in. And if, and there's other circuits have said, if you just want to show felon in possession, that's fine, but don't go further and have much more graphic evidence about how the gun was then used. And so since there's a balancing required and the government did not at trial argue, we want this admitted for felon in possession purposes. How could this court make that balancing, whether this evidence and the sort of toxicity of it was warranted to show felon in possession?
I think this
You're asking
court,
us to make that judgment for the first time.
well, I think this court,
Balancing judgment.
I think when there are alternative bases for admission, this court can make a determination, even if it wasn't relied on by the district court.
What is your best case that when it involves an exercise of discretion by the district court, that this court can make that discretionary decision in the first instance? This court can make all kinds of legal rulings in the first instance.
Sure.
generally when something involves an exercise of the district court's discretion, especially as something as sensitive as a balancing of prejudice and prohibitiveness and exactly how much information needs to be let in to demonstrate, for example, felon in possession.
Sure.
That's a judgment that needs to be made by the judge that is sitting in the courtroom
Well,
all day, every day.
my opponent, when this was litigated during Mans's testimony, my opponent didn't raise the issue of 403 at all. And so I think to the extent that there
I'm
was.
asking you if you have a case that has said that this court can, in the first instance, make that type of very delicate balancing when it wasn't argued that way to the district court, and the district court didn't have a chance to exercise its expert discretion on the issue. What is your best case?
I don't have a case.
Any case.
I don't have a case at my fingertips. I
Or of
apologize.
any case where a court of appeals had made that type of discretionary judgment in the first instance.
I think this court assesses discretionary decisions all the time, but
When they're made by the district court judge, absolutely. We do not make the discretionary decision. We evaluate their discretionary decisions, but we don't have the discretionary decision of whether this, to the degree, the way it was introduced here, the story about the gun to her temple.
I agree.
whether
That's
district
I
judge-
agree. That's a missing fact. Yes.
I'm not saying fact, it's a missing discretionary judgment, and there's Court of Appeals decision, I think it's the Seventh Circuit, that said you can let the fact that a witness could testify to the fact that they saw the person with the gun, but could not, in that case, go further and testify things about Russian roulette being played with the gun. And it seems to me that's very similar to this case.
Well, I'm not familiar with the Seventh Circuit decision. I apologize. But even if this court were to disagree with the conclusion that this was properly admitted, it's certainly harmless. This was an 8-day trial.
But on Judge Millett's point, wouldn't it be plain error review? If it was never raised as a 403 issue, the court never ruled that way. There's no case on point, but it's plain error review. On 403
I think it would be, and that gets to my core point when I mentioned that defense counsel could have, when this was posited to the district court with respect to the gun and Mans. Certainly, defendant was on notice of the gun to the head incident. That was part of the government's pretrial motion in limine relating to the 404B evidence.
Right. So they should argue it's substantially more prejudicial than probative.
I think that's
should be excluded under 403. And if they didn't know it was coming and it came, they should have objected contemporaneously and made a 403 argument, and then we'd be where we are. But if they never did that, we're on plain error review. Are we?
I think that's accurate.
Why are we on plain
Okay,
error
okay.
when they made this objection repeatedly before the district court, and again at trial objected to the admission of this evidence?
Well, they addressed the 404B argument that was related to the gun. But again, to my mind, the district court,
They objected to the admission of this evidence.
yes, but
You're the one who wants to bring up a whole new balancing thing for felon in possession. They couldn't have on appeal. You want to bring that up. That's
Well,
not something they could have anticipated.
Again, I think it's not too much to ask when you object to evidence, you articulate why you think it's inappropriately
Even if you've
not
already had an
irrelevant.
entire motion in limine before the district court, what's your best case when you've had an entire motion in limine that has spelled all this out, and now you're in front of a jury and you want to you make your objection again? What's your best case that is not sufficient? We get plain error review.
Well, again, I think I understand plain error review to stand for the proposition that you can't sort of sandbag the district court and allow evidence to come in. In this case, again, it seems, again, my opponent doesn't disagree with the notion that this is relevant to the felon in possession. And if we understand that concession to stand for the proposition that it has some probative value, then I don't think it's so much to ask to the district court to consider what your basis for objection is.
But it's not asked to admit this as evidence of felon in possession.
Well,
It's not the government's position. I don't understand this world where the government doesn't have to make arguments, but the defense is supposed to have objected to the unmade arguments.
well, again, I think, as my opponent
And if
has.
they don't object to unmade arguments, we apply plain error review.
Sure. We disagree on this, but again, even if we're
You have
not.
a case where they didn't object to an argument that's not made until appeal, and that's treated as plain error?
I don't have the case on.
And I can't imagine. I mean, what are defense attorneys supposed to do? I'm objecting to this. And by the way, if the government in some future time wants to argue this, I'm objecting to that.
Well, again, this was not something completely foreign to the defendant.
That's not the question.
This
Completely foreign isn't the question. The question is whether it was the basis on which the government sought admission of the evidence.
Well, the defendant did make a 403 analysis in its response to the government's pretrial motion. So the notion that this was a laden emotional fact is something that everybody was on notice.
They did invoke 403?
I'm sorry?
If they did invoke 403, then why are we talking about plain error?
Well, they invoked 403 in response to the government's pretrial motion. My point is later they did not make that argument with respect to the actual admission.
So is that, what were they supposed to do? I thought what happened was pretrial, this issue came up and then it was tabled.
Yes, it was tabled. Yes, absolutely.
So then the objections that were made before don't carry through? There's an obligation to.
Well, I think they were answering the 404B argument that was made in the government's motion. And the gun had a separate purpose when we got to trial. It was direct evidence of the felon in possession. And if they wanted, and that's an important part of the balancing. You ask the question of how is this relevant and what probative value does it bring? And the gun, obviously, there was much discussion of the gun at the trial. So the gun is relevant evidence related to at least one of the counts of the indictment.
When there's a back and forth at the trial, the theory that was being asserted for the admission of the evidence was not felon in possession.
It did not specifically arise. No.
Yeah, but because it had to do with, it wasn't coming in for that purpose. It was coming for a different purpose.
Well, again, that was the way it was argued pretrial for sure. Then it was pushed off. But I certainly think it's a fair inference that everybody understood that this also had relevance to the felon in possession.
I don't understand fair inference that everyone understood. Where in your brief to us have you argued that this issue, the admission of this testimony, is subject to plain error review?
It's not in our brief.
You didn't. You argued that it was abuse of discretion review.
Yes.
Okay. Even if one thought it was, you have forfeited that.
I could see the court's perspective on that.
Or maybe we should understand that you understood the record the same way defense understood the record. And that is that this was a preserved argument and that the shift to felon in possession is something that's made on appeal, but was not made before the district court judge.
Well, again, it wasn't overtly made for sure.
Overtly made. I mean, what was made and what the district court relied on was that this would be this very, very potentially toxic or potentially prejudicial, but certainly toxic evidence was going to be admitted subject to the government connecting it up to the argument that it was argued that this would show coercion, that he was someone who engaged in coercive levels of force. And the government promised in limine and at trial that it was going to connect it up to show that the girls were aware of this incident. Correct?
Yes.
Okay. What evidence did the government ever have that the girls saw this incident?
That the girls were aware of this incident? There is no evidence that I know.
Was there ever?
I'm sorry?
Was there ever?
Not in the trial that I saw, no.
No, and by the time this came on, Ms. Demands testified at the end of near the end of the trial, correct?
Yeah, I don't know exactly.
CS had already testified, and the government didn't ask her if she was aware of this incident, had even heard of this incident, let alone seen this incident. So the government right there with ZS on the stand, it didn't do what it said it would do. And every other witness pre-man never had any foundation laid for connecting this incident to the argument about use of coercive force against the girls.
True.
Yet the government, when Ms. Mans comes to testify near the end of the trial, goes ahead and puts it in knowing that the promise it made to the district court judge about connecting it up was not going to happen. It hadn't happened. The questions weren't asked of anybody, let alone the most material witness, ZS. It was nowhere in the grand jury testimony of THY that was read into the record. And as you've said, there was never any evidence in the record that did tie it up. And yet the government went ahead and put it forward before the jury.
Well,
What are we supposed to do with that?
Well, there were two routes for admission pursuant to 404B relating to this incident. The first, as Your Honor has identified, was that the girl's knowledge would constitute direct evidence of the climate of fear. But the other route to admission for this 404B evidence, and was argued pre-trial, was the same rationale that was used with respect to Ashley Taylor. That is, it answered the question of whether the defendant, Lewis, acted knowingly with an intent to coerce, use force or threats of force. And in this context, it showed that he did it both with respect to the victims, the minor victims, but also his underlings in the conspiracy, both Ashley Taylor and his wife, who was also a co-conspirator. So, and in fact, when you look at the...
There's some offense here for coercing underlings that was charged?
No, but I think it's...
Okay, but then I don't understand how this evidence was relevant to the charges before the jury.
Well, again...
He's a violent man who should be locked up.
I don't think it's that simple. I think, excuse me, I think the 404B relates to, and this is the Getty's case from the Eighth Circuit. This was a 1591 prosecution. It involved prior acts of violence, physical assault, and a threat to kill his girlfriend, his ex-girlfriend by the time of trial. And Getty said the ex-girlfriend's testimony about the defendant's earlier use of force against her was relevant to the issue of the defendant's intent, which was a material issue at a trial. So I think this was
I don't know all the details of that case right now off the top of my head, but it doesn't connect it up for me. How was this relevant to his intent to use force to coerce the girls into commercial sexual acts?
Well, it showed that when you're asking the question, coercion was put in play. The defendant...
Coercion for a particular purpose, not does he coerce people to do other things. I mean, that's propensity. That's saying he's just a violent man. That is exactly the definition of propensity.
Well, again,
How do you define propensity?
That's the definition that I understand.
Great.
Yes, I don't think that's what this was used for. I will say,
I take it the government's theory is if Lewis were in the presence of the two minors brandishing a firearm against his wife who was there, and then he said, "This is what happens when you don't pay attention to me and do what I say," and he says that in the minors' presence to the minors, then I could see, that's a theory about force and coercion. I'm a coercive guy. I use coercion. You see how I'm doing this. Don't disobey me. Do what I need you to do. And then you may not need that kind of explicit connection made by Lewis himself, but I take it, is that roughly the government's theory, is that that was the first route of admission that I was articulating. Again, the second route I'm sorry, go ahead, Your Honor. No, go ahead.
The second route to admission is a mirror image of what the trial court did with respect to Ashley Taylor. And that ruling preceded this one, and it was, apologies, that's the July 12th, 2022 PM transcript. At 54, the court considered violent acts against Ashley Taylor that were not necessarily known to the victims. And the court said Taylor was Lewis's bottom, who was acting on his behalf because she was afraid of his violence. And then the court did a 403 balancing test analysis at that point. Again, that's page 54.
That may have gone to Taylor's own liability. The rest being a defense.
Well, again, the government offered as proof of the mens rea relating to defendant Lewis, and that was the
Mens rea for what?
mens rea of defendant Lewis.
For what?
Oh, for which element? To show what?
Intent to commit coercion, force of threat.
For what? I'm sorry, I misunderstood. I'm sorry, I just didn't quite hear it. Intent to commit coercion for what?
Force of threats. I meant threat of force. I'm
Just in the
sorry.
abstract?
No, it related to the defendant's activity in the course of this conspiracy.
Okay.
You
When
know,
did this incident with Ms. Manns occur?
I'm sorry.
When did the incident with Ms. Manns occur?
It was specified within the time frame in the conspiracy.
No,
That's-
it was specified as April 2019.
Well, I
That's all the
believe
record
that-
says.
I believe the question was,
They never asked her the date. And the conspiracy didn't even start till the 25th of April. So the vast majority of April was not even part of the conspiracy.
right, that was the trial assistant at page 82 of the 517 transcript, AM, said she was confining it to the time frame of April 2019. But of course,
That's not the conspiracy.
well,
24 days of April 2019 are not the conspiracy.
well, I understand.
23.
On or about, we know that conspiracy indictments don't always necessarily have precise dates. We
This one
take,
is pretty precise. We know the dates, the girl's
Sure.
eyes were found. This one has a pretty precise one.
Yeah,
What happened
on or
April 1st
about.
or 2nd?
yeah,
Would
I-
that fall within this conspiracy?
I think
And
it
he's just
could,
violent on April 1st or 2nd?
I think it could well, if we're talking about on or about.
The government didn't tie this up. It didn't tie it up to the girls as it had promised the district court, the whole basis for letting it in. It's got no tie up to the conspiracy itself because it didn't ask the date, which would have been the obvious thing to do. In fact, it even argued that, wow, this was important. The fact that the gun was held to her head was how she would remember the date, but never asked her the date. This was, I think, as you said, to show propensity for coercive force. That's what you said. And that's just not admissible.
For the record, I just want to be clear, I'm not conceding this was propensity evidence. If you're suggesting that my answers reflect that, I want to make it clear that's not what
We
I'm
asked you
doing.
what it was relevant for, and you said to use coercive force.
The intent, that's
Intent to use
intent,
coercive
absence
force.
of. If I can, I would like to address the harmless part of this.
Yeah, I want to hear that actually, but can I want to make sure I understand this. So the provision says knowing or in reckless disregard of the fact that force, threats, force, fraud, or coercion will be used to cause the person to engage in a commercial sex act. For the gun evidence vis-a-vis Manns, who is the person that's the subject of the force, fraud, or coercion to cause them to engage in a commercial sex act?
The subject is the victims.
The minors,
Yes, yes.
not Manns.
No, but I think that would be right. Yeah, no.
So the
Yeah.
minors.
Yes, yes, yes.
So then just to understand the theory is that because he used a gun against Manns, how does that bear on force, coercion, or fraud to cause the minors to engage in a commercial sex act?
Well, I think it facilitated his ability to operate the conspiracy. That is, she was part of the Cash App part of the conspiracy. And in fact, later in her testimony, she made reference to the fact that she only did that because she was.
I see. So
Yeah,
it's forcing Manns.
yes. And just as, he forced Taylor to participate and work with him in the course of the conspiracy, that informs, I think, the intent analysis of 404B.
So he used force against Manns to enable the conspiracy
Yes,
that involves
Yes.
sex trafficking of the two minors.
yes,
That's the second theory.
yes,
Okay, then on harmlessness.
sure,
So what's the burden's on the government to establish harmlessness if it's
sure.
is an error?
Didn't involve a substantial and injurious effect. I think we have several features of this case that demonstrate that wasn't what was going on here and that this court can be confident. Number one, this was an 8-day trial. There were over 1,400 pages of testimony. This was 16 lines of transcript. Critically, it also wasn't mentioned in closing arguments, neither the government's initial opening or its rebuttal. More saliently, even in that, we have the acquittal of Mr. Lewis on one of the counts of the indictment. That suggests that the jury was not engaged in sort of a broad brush attack or engaged in propensity-based guilt or innocence adjudication. If they were considering him as just simply an evil man, they wouldn't have had an acquittal with respect to count 13. I would also say the jury heard plenty of other evidence regarding Lewis's violent nature. He choked Ashley Taylor. The testimony relating to that, I'm sorry. Oh, I'm sorry. He choked Ashley Taylor, and the testimony relating to that was he said to her, "If you keep fucking up, I'll kill you." That's at May 13th AM transcript 7576. He grabbed and threatened Jones and said, "I'm going to shoot the whole shit up." That's page 117 of the 5/12/22 PM transcript. He also told Fowler that he'd arranged for a kidnapping to keep him quiet.
How does this go to coercion of the minors again? Because ZS testified that she never saw this violence. So I get that there was conflicting testimony, right? Taylor says one thing, ZS says she never saw violence.
Well, the testimony relating to the choking was that the minor saw that.
I understand it, but then ZS said she never saw violence, and he was never violent towards her or THY that she had seen, and she didn't see any of this violence against Taylor. So I understand you got your evidence, but there's a clear conflict in the evidence, so that doesn't help so much with harmlessness, does it?
I think it does. This evidence was not challenged, and
That's whether it was challenged.
it was
The question is
properly.
whether there was evidence that the girls were aware of his threats related to this operation, to them or to this operation.
And with the pieces of testimony I just cited, I believe the testimony indicated they were
What
aware.
does ZS say about whether she saw him engage in any of the violence acts you referenced? Obviously, not the Mr. Fowler one.
That might have conflicted with Taylor's testimony, but I believe Taylor.
That's it.
But I don't think conflicts in testimony necessarily negate the harmlessness point that I'm making.
I think it's really so much more important, doesn't it?
There was also substantial evidence of.
Can I just ask on all this evidence? If, let's suppose it's undisputed that the minors never knew about or saw any of this. I know you would resist that because there's at least conflicting evidence, you'd say, but just as a matter of theory, if that was never something the minors were aware of, would you still be making a harmlessness argument, or does your harmlessness argument contingent on accepting the proposition that the minors were aware of or saw?
No, not at all. I mean, I think what this back and forth was reflective of is that I had cited that there were other instances of violence that the jury heard. And there is somewhat contradictory evidence relating to whether or not the girls saw that the defendant choked Taylor.
So isn't it correct that your harmlessness argument that you're making right now addresses the idea that Rule 403 was violated and there was unduly prejudicial evidence about his violence that might have influenced the jury?
Yes.
You're saying that is really cumulative of all the properly admitted evidence that showed he was extremely violent. I thought that was
That's what I'm getting at. And that's why.
Not the knowledge of the victims, which is a separate issue, which maybe you could address. But this is what you're arguing right now is saying to the extent that Rule 403 was violated and there was inadmissible to prejudicial evidence of violence, that was cumulative of lots of other evidence properly admitted of violence. Is that right?
That's exactly it. Albeit much more artfully.
But you have to show that it was harmless as to the jury's finding of guilt, including the forced coercion or fraud element, right?
Yes.
And is your theory that even if the victims, the minor victims, didn't know about any of this, that it still shows harmlessness?
Yes. Yes. Again, because from our perspective, the citations I've just provided was properly admitted evidence that the jury heard otherwise. And so if you're asking the question of how can we be comfortable with the idea that this jury wasn't influenced by this testimony, we can consider whether or not they had pieces of testimony that were of the same ilk. And we know that they had testimony that was of the same ilk when we look at the descriptions of the assault on Taylor, the descriptions of the assault on Jones, and the defendant's own admissions when he told Fowler that to keep a witness quiet, he had kidnapped somebody previously and in fact, was a member of the Crips. So I think that's just a piece of the harmless error analysis here. I want to make that clear. The fact that it wasn't mentioned in the closings, that this was a lengthy trial, tiny bit of testimony, wasn't emphasized. We have the acquittal on count 13, and we do have a limiting instruction, which if this court decides this was improperly admitted, we know that the court instructed the jury, this is at the May 19th transcript, page 42, that you've heard evidence of other acts not charged in an indictment. You may consider them for only the limited purpose that he acted knowingly. So we already have them not being able to use it just for guilt or innocence. And then I would be remiss if I didn't at least go through some of the powerful corroborating evidence that supported both the victims, the minor victims' testimony and Taylor's testimony. We have the loyalty contract that the defendant wrote that was on his computer. We have the handwritten notes of the rules he had for the victims that were found in the trunk of his Cadillac. We have contemporaneous texts from the defendant, from Taylor to the girls, quoting Lewis. One, for example, said, even though the girls had claimed they were sick and couldn't take commercial sex acts, he said, she said, you could only sleep if it was okay with Lewis. In another case, they asked if they could sleep. Taylor responded, Lewis said there was not enough money being generated. That's exhibit 115B. We also have the cooperator Fowler, who was in the jail cell with Lewis for, I think, a good month. And Lewis revealed many details of the conspiracy. He talked about the loyalty contract to Fowler. He talked about the Cash App transactions. He showed him paperwork for that. He even showed him paperwork relating to the motels. In addition, we have the cell site location information, which corroborated Taylor and the victim's testimony relating to the travels of Jones and Lewis. We also have motel receipts in the defendant's name. We have Cash App transactions that were admitted into evidence. And then we even...
I think a lot of this, what you're talking about now, goes to whether he was involved in the commercial sex activities. That's just a separate question from whether he was engaged in coercion. So, I mean, I think that's all your travel. He had all the financial information, all that kind of stuff definitely goes to that. But I'm not sure it goes to this coercion question.
Well, the loyalty contract, just to pick an example, sir.
I know, but then again, you got Diaz's testimony. They didn't feel they had to sign it. They didn't feel it bound them to anything. So.
Sure. But again,
that goes to, was he in this business?
I think
when the victim itself says, didn't feel pressure to me, I can sign it or not.
Well, it was a constellation of factors here. The loyalty contract was one element, the omnipresence of the gun, the assaults that I've already mentioned on Taylor and Jones that were known to the children.
Whether they were known is a disputed fact. I don't know for harmlessness. We don't.
But I think we take
the view in favor of the government in deciding whether something the government did that was mistaken.
I think even in the context of harmless, it's all reasonable inferences should be drawn in favor of the government.
Is that our case law?
Because we have jury verdicts, I think that's.
No, but if the whole point is that the government's error, if we agree that that's what happened here, or the district court's error, whichever way you look at it, we're trying to decide whether it was prejudicial. We have to look at the whole record.
Sure.
And whether it could have had an impact on the outcome of the case. And I'm not aware of any case that says, and we assume, in doing so, we assume hotly contested factual disputes in favor of the party responsible for.
I think
the
my
error.
point is more limited. You can't dispense with the evidence, but I suppose you can.
Right.
You can limit its value if it was in
Not
fact.
limited, if you go, well, it actually cuts the other way. If what's the argument is bears on something that is in fact factually contested. And so the improper evidence could have tilted the jury's view on that disputed question of fact.
I think that's a proper way to analyze harmlessness. But again, that's just a piece of the puzzle that we have for harmlessness here.
Colleagues, are you done on this?
Yeah.
Could you talk about the reckless disregard instruction?
Certainly, Your Honor.
So this instruction that was given has no precedent. It doesn't match the Judge Sand's instruction in some pretty critical ways. It doesn't match the background, well-established, longstanding rule of what reckless disregard means in the criminal context at all. It totally omits subjective inquiry. So how was this not, and given how contested the question of coercion was, how was this not a harmful error? How was it not an error that was harmful and prejudicial?
Well,
In a plain error sense.
in the plain error sense, I think most fundamentally, I think the prong two is, I'm sorry.
I can say that.
I think prong two has particular resonance here. I know of no authority that has defined reckless disregard in the 1591 context. This one wasn't a mirror image of Judge Sands' instruction, but it was very close to it.
No, it was some pretty serious deviations, high probability and highest probability. Just in plain English, material difference.
I don't.
And this, the fact at issue, and the fact, I think, must have kept changing through that sentence, or I don't know if the jury even knew which fact they were supposed, and they were told just one fact when there were multiple facts that had to be resolved in that instruction. That's pretty important errors.
Well, even if we discount, and I don't think you should, but even if you could discount Judge Sands, my opponent has not.
Counting Judge Sands, I'm discounting the instruction that was given here that was material departure from even Judge. It departed from everything that has ever been before as a reckless disregard instruction.
There was a variation for sure, but again,
Variations.
But again, I understand plain error stand for the concept that unless you can show a settled rule of law.
Well, we've held that there's a settled rule of law as to what reckless disregard means in the criminal law context.
Well, again, I don't think that's what the cases reflect, and that's what we've argued in our brief. And in fact, if you look at the Farmers case, the Farmers said reckless is. This is 511 U.S. 836. Recklessness is not self-defining. So I think if we are accepting the proposition
Of
that
course, told us what it means in the criminal law context.
Generally,
We have cases saying what it means in the criminal law context.
I'm sorry, do I?
We have this court has case saying what its longstanding background meaning is in the criminal law context. Supreme Court said the same thing in Farmer. And there's nothing in the text of 1591 that I see here the government arguing pointed in the other direction. But even if we say at most there's two options, there's the longstanding criminal law definition, or there's this Judge Sands I'll call it a definition for purposes of an instruction. But we had neither one here. And coercion was a very contested issue here, and the evidence is, a lot of the evidence that was used is troubling in its own right, and it's
Well-
given ZS's own testimony. It's a really close question. I'm not saying the government couldn't have won on a proper instruction, but we have an instruction that doesn't
Well-
fit anything. Are you aware of any court anywhere that has used this instruction from this case for reckless disregard?
I think,
criminal
I
case.
think I cited two in the 1324.
Not the Judge Sands one, the one that was used in this case.
I don't know of any,
There's no
but
evidence ever been used.
but in the 1324 context, there's similarity.
They followed the Judge Sands
Yes.
one. I'm not talking about the Judge Sands one, because this one is not.
Again, I think it was very close. And if we're talking about variations at the edges, then I think we're pretty solidly in the plain error context, not showing clear or obvious error. If reasonable minds
There
can,
were a legal rule that the government had to show a high probability that something happened. And a court instructed the jury that you must find that it happened by the highest probability. That matter to the government?
well, I think that
That matter
excises,
to the government?
I think that
Does
excises,
that matter to the government? If the jury, if the law was high probability, that's all the government has to show. And a jury was instead told, you must find it by the highest probability. Would that be a material difference in the government's view between the law and the instruction?
I'm not sure I would say it was. I don't,
Really?
I don't see the significance.
Between
that-
high and highest?
I
More
don't,
probable than not or beyond a reasonable doubt? Not much difference.
I think,
Highest probability is as high as can possibly be. That's almost like a reasonable, I'm not saying it's the same thing, but it's a very high standard, almost like reasonable doubt. High probability, that's just more likely than not.
again,
It's even less than more likely than not, I'm not sure.
Again, we disagree about this, but if we're talking about plain error and clear or obvious error, number one,
The fact at issue, that's not Judge Stan's instruction.
if I could turn to prongs 3 and 4, because I don't think the critical question here is whether or not this was a closed case on coercion. I don't think it was. I think the critical question here is whether or not there was any sense that this defendant was somehow or another a bit player in the larger conspiracy where the jury would have to beckon to the notion of an ostrich sticking its head in the sand. And that's the analogy used by the Carson decision out of the Seventh Circuit. This would have more resonance if the government had even mentioned reckless disregard in its closings. It didn't. The primary theory here.
Is that so? I was going to ask that question. Was reckless disregard part of the government's
No,
argument?
no. The
I mean,
government.
the jury obviously could have found it anyway, could have found it on that theory, but I'm just, in terms of the way that was presented to the jury by the government.
It was presented to the jury in one way. Either you believed that this man was the main player or you didn't believe that this man was the main player. Reckless disregard just simply didn't come into play. And that's, I think, the Carson's analysis here is when you have significant evidence relating to the actor himself who is either doing the forcing or the threatening or the coercion, then you don't have to beckon to reckless disregard as a lesser standard of proof relating to mens rea. And I think Carson is directly on point in this regard. It was a 1591 case. It was an erroneous instruction that they found there, but they said that makes no difference except in those cases where you have characters like the driver who just drops off the girls at a designated point. And that is not this. The jury would have had to go off on a frolic and a detour to rely on any purportedly erroneous instruction relating to reckless disregard.
Did Carson not predate Congress's amendment of the statute to change what reckless disregard meant?
I don't know the answer to that. I apologize.
Did.
I thought Carson dealt with a reckless disregard, erroneous instruction, but.
It did, but it was
Okay.
before Congress amended the statute to resolve I think what may have been a circuit conflict or confusion on a different aspect of reckless disregard. So.
But I think the analysis still holds. If they conclude their reckless disregard instruction was erroneous, but they nonetheless say it didn't have an impact under prongs 3 and 4, I think that analysis applies here.
And then on, there's one aspect of the sentencing, at least, that if we can go to that, there's one aspect of the sentencing, at least, as to which the government doesn't dispute that findings need to have been made that weren't. And so I'm right about that, right?
I'm sorry, I missed the front end of your question.
There's one aspect of the sentencing as to which the government does not dispute that findings needed to have been made but weren't.
I think we said remand may be appropriate. And in that respect, I want to pause here if I could and just grab 20 seconds of the court's time. Something that wasn't apparent to me when I was writing the brief, but as we were getting ready for argument, was brought to my attention. And I think it's just important. This court, of course, has an independent duty to do a harmlessness analysis. But when you look at the base offense level vis-a-vis the final adjusted offense level, I would note that even on the adjustments that my opponent challenges, we would still come out to a 43 base of adjusted offense level. And so I read the calculations to stand for the proposition that we're not in a different guideline range category. We're in a similar guideline range category. Now, I bring this to the court's attention.
So that's true. If there's remand on all three, the computer leadership and vulnerable victim, I think you're out of the life sentence and into it's 360 to life, but you're in a range that is not automatically life.
Well, my opponent, I don't think, is disagreeing with the notion that at least a 2-level adjustment for leadership would be appropriate. So I'm only saying the 2 points for computer, the 2 points for vulnerable victim, and the 2 points for leader enhancement would still get you to 43. And that puts you in the same guideline range. But again, I bring this to the court
for computer, but you agree that we have to remand for fact finding on that. 2 points for leadership, but the district court didn't make findings about how many people were led here. And then 2 points for vulnerable victim. But even if we had a test for what vulnerable victim means, you have to find, and there were no district court findings, that Mr. Lewis was aware of the facts that made these girls vulnerable, even if we look at the facts that are common to minor sex trafficking victim.
No, I agree that the court did not make findings of fact relating to the vulnerable victim. On that note, as my opponent was arguing, one question related to whether this should be a global remand or a more nuanced remand. McCants, I think, speaks to this. McCants went so far as to say that although the parties urge us to rule on the proper interpretation of this, in that case, sophisticated means enhancement in the guidelines, it would be inappropriate for us to do so in the absence of more specific factual findings by the district court. And excuse me, that's 434 F3rd at 564. So at least in the context of McCants, a case we cited relating to when you do have important missing factual findings on pivotal sentencing factors, McCants says, well, we shouldn't be in the process. I read McCants' standpoint, we shouldn't be in the manner of issuing advisory opinions on the nature of the enhancement, because I read McCants' standpoint the proposition, it may be mooted out if the district court doesn't even find the vulnerable victim enhancement. If
Any more questions?
I had just one comment. I think that this sentencing was problematic because the district court, after hearing lengthy allocutions from both sides, did not address the arguments that were made by the defense or the government when it gave its sentence. And I just want to note that the government has an obligation to also make a record here. And I don't see why the prosecutor didn't say, Your Honor, we'd asked for the record that you make some factual findings on issues A, B, C, and D. We've got the defense attorney doing that. I see nothing from the government doing this. And I just don't understand why the government is not protecting the record and making a record to support a conviction that it fought hard to achieve.
Well, I can assume the government, I haven't discussed this with anybody, but I can assume the government was relying on its own pleadings relating to, these were hotly contested issues for sure.
Oh, so you're defending this? You think that this is an appropriate strategic or legal performance by an AUSA
No, I'm just
at a sentencing hearing after making allocution and hearing the defense arguments and seeing a record that clearly is going to go up in appeal and probably going to get reversed because there are no factual findings, that the AUSA should sit there mutely?
I'm just suggesting that we could maybe ascertain why there weren't more vocal objections.
I just don't see why you would defend this. I'm only making this comment for future reference for the government.
Okay. Thank you, counsel.
We would ask that you affirm the judgment and conviction. Thank you, Your Honor.
Mr. Jones, we'll give you 2 minutes for a rebuttal.
Thank you.
Well, the only issue I want to make, because since this is rebuttal, the only issue I want to make is with respect to when my client was involved in the alleged conspiracy. She got involved April the 26th and was out April the 27th. Why that is important is because the loyalty contract that came through on her phone, that was presented on April the 27th before she went to Greenbelt with the young people, and after she had been banished, because when she came back, when nothing worked out.
I don't see how that helps. She was aware of the loyalty contract he was going to use with these girls that she said wanted work, and she was bringing to him for that work. And she's seen the loyalty contract. I just don't know how you can say she was divorced from what happened with those girls as part of his trafficking of them.
Well, it's clear that
Loyalty contract says, okay, here's what's going to happen when you bring them here. Here's how I'm going to get them work, and here's what I'm going to require of them.
and then
Okay,
immediately,
drive them on up. She takes them to him twice. She takes them to them, and then she goes off to Greenbelt and brings them right back to him.
and nothing happened in Greenbelt because she stopped it, at least according to the evidence, because she stopped it, and because she stopped it, she was,
She didn't keep driving and take the girls away from Mr. Lewis. She had the loyalty contract. She knew Mr. Lewis. She knew what he did. That's why she took him to them for work. And so I just don't quite understand how that allows her to sort of wash her hands of this, of what happened afterwards.
well, that time she was threatened with physical violence to herself, and she elected to
Yeah,
do the rest of it.
I'd peel out from there for then, sure. But that doesn't mean she's not responsible for what happened. Or part of the conspiracy, I should say, not responsibility. Responsibility has many forms in a case like this, many responsible people, but she's part of the conspiracy.
How would this conspiracy shifted from there? Because at that juncture, they were not going in any hotels. They weren't staying in the hotels, and they did immediately leave there and go to the Motel 6, and then after stayed there for approximately 4 days, and after there went to the Condo Lodge. So that had nothing to do with her, because that's when they met the people and they were having the commercial sexual acts. There were none done while she was there, or her getting any funds from that, participating in it, of the like. She was out of it and banished.
Okay. Let me make sure my colleagues don't have additional questions for you. Thank you, Mr. Jones.
All right, thanks.
Ms. Millian will also give you 2 minutes for rebuttal.
Thank you, Your Honor. We've been here for a long time, so I don't want to keep us here too much longer. But I just want to note the government has raised a new argument at the podium about harmlessness at sentencing. And I would just note that it's this idea about the 2 points not affecting the guidelines range is something that's been waived because it's not been briefed. And, you're not supposed to bring it up for the first time at the podium. And I'd also just note that notwithstanding that fact, Mr. Lewis received a 2-point enhancement for obstruction of justice based on the acquitted conduct related to Mr. Fowler. And the guidelines range they've since been amended, and on a remand, we would, raise the argument that the guidelines have changed and those 2 points shouldn't apply. So even then, this issue is irrelevant given that, on remand, we're going to be talking about a different guidelines range. So that is sort of the main point I had. If there are other questions from Your Honors, I'm happy for them. Thank you.
Thank you, counsel. Thank you to all counsel. We'll take this case under submission.
Case number 24-7154. Cheryl Walker versus Uber Technologies Inc. et al. Appellants. Mr. Huston for the appellants, Ms. Clayton for the appellate.
Good morning, counsel. Mr. Houston, please proceed when you're ready.
May it please the court, I'm Michael Houston of Perkins Coie for Uber. The district court's decision denying the motion to compel arbitration should be reversed for 2 independent reasons. Both are important. I hope we'll talk about both. First, contract law in the District of Columbia, as in virtually every state, uses an inquiry notice standard. A contract is formed so long as a reasonable person would have had an opportunity to view the terms before agreeing to them. That's the DC Court of Appeals in Forrest and this court in Selden. Uber's text message to Carol Walker provided that reasonable opportunity. Uber made no attempt to obscure or hide from Mr. Walker the fact that by agreeing to take this ride, he was required to agree to the contractual terms of use. On the contrary, we sent him a text message providing him the most critically important information about the services he was using, the car and driver that would be picking him up. And in that same message, even before that most important information, Uber stated in plain, easy to understand language that by taking this ride, Mr. Walker would agree to the terms of use. A reasonable user of Uber's services would have read that text message, so it created inquiry notice of the contract as a matter of law. Second, and independently.
So I think that your view of inquiry notice is pretty narrow. It seems that the law requires a fact-intensive totality of the circumstances approach, which goes beyond what you just said. You have to look at the course of conduct between the user and the business, and this user didn't have an Uber account or anything like that. You have to look at the type of transaction it is. We're not buying a house or a car. It's just a ride, things of that nature. And it seems that to me that your analysis ignores a lot of other facts. The bottom line is this was an unsolicited text that, he may or may not have looked at, and he says he didn't. And is that enough to create inquiry notice under every circumstance? You're saying it is. Well, You're saying we should just assume anytime Uber sends a text like this, there's a contract. And I find that difficult to accept.
No, respectfully, Judge Penn, I don't think our position is saying that. I don't think we're saying any text message.
Well, any text that says your ride is coming forms a contract to the rider,
no,
according to you.
I think a contract was formed because this was the most direct communication that we
Correct,
had.
but aren't you saying that anytime Uber sends a text that says your ride is coming, a reasonable person would open that? I feel like that's the crux of your argument.
In the
And I
context
think
of,
there's more to it.
in the context, I think all the other, you're right, that the inquiry notice standard takes account of the facts and circumstances. All of the other facts and circumstances here weigh in our favor. That's why the district court found that Mrs. Walker was bound. That's why courts around the country have repeatedly found that the same
But does your position then boil down to anytime Uber sends a text that says your ride is coming, that forms a contract?
No.
Because any reasonable person would open that app to see the terms and conditions. It doesn't boil down to that?
No, it does not boil
Okay,
down.
under what circumstances would somebody receive that app and not be bound?
So
Not have been cleared?
I think the point, Your Honor, is Mr. Walker cannot evade the.
But can you answer my question? Under what circumstances would Uber send that app and there would not be inquiry notice?
So I guess I'm not sure. I don't think Uber, in the context of Uber sending a message to a user about the ride that's coming to pick you up, about the services that you have requested, I think that is the best way for us as a company to get that information in front of the user.
So I'm just trying to understand your legal position. I read your legal position to say that anytime Uber sends one of these texts, a reasonable person would open it and they would have inquiry notice and there would be a contract at that point. And you said, no, that's not it. And I'm asking you then, under what circumstances would Uber send that text and it would not form a contract?
I
There
think-
would there would be no inquiry notice.
Let me try to clarify.
Can you just answer that directly?
Sure. I want to clarify our position. I think when Uber sends this text message to a user and says, these are the details of the ride that's picking you up, and to accept that benefit, you must agree to the contract, that is reasonable. That suffices.
Anytime they send the text,
Yes.
period.
Well, yes.
So there is no situation in which they would send a text and no contract was formed.
Well, the user would have to decline. That would be when there's no contract form. When the user says, I'm not willing to enter this bargain, I'm out. I don't want.
No. I think you're assuming your whole position is a reasonable person would open the.
Yes, that is
or
correct.
the text.
It is not
So which
commercial.
means that anytime you send the text, period, we're done.
As long as the text is received, yes.
Okay, anytime they receive it. Go ahead.
What if they have a flip phone?
So, Your Honor, I mean, there's nothing in the record to suggest.
What if they did?
So I still think that most flip phones are capable of receiving text messages. Most flip phones have connection to the internet.
So I take it, Uber prides itself on providing drivers quickly, right? That's the goal, obviously, is to send a driver as quickly as possible. So if it's a minute and you have a flip phone, is the upshot of the theory, and you're a guest. I mean, I understand the situation in which you're first subscribing for the service. That's kind of like being on a website. You got time, you can research it, you can do all the stuff. If you're the guest and Uber is doing its job really, really well, so the ride's going to be there within a minute, and you have a flip phone. And I take it Uber still has, I think it's the case that if you don't get in the car soon enough, the ride's gone. So what in that situation?
So-
You have a minute and you have a flip phone.
So Chief Judge Srinivasan, there's at least two reasons why Mr. Walker can't and didn't make that argument on this record. I mean, the first is he knows what kind of phone he had. He never attempted to argue.
Well, I'm sorry, I totally understand where
Sure.
you're going, but in terms of the theory, in terms
Sure.
of your theory in response to Judge Pan, I'm just wondering, does your theory apply in that situation where the person in fact does have a flip phone and where the ride is coming in a minute?
Yes, it would. I mean, it's not the record here. And I want to add one more note about why it's not the record. And then I would promise I'll answer your question directly. The reason why it's not here is Mr. Walker, the record shows, had taken at least 5 rides before this one. So even if there had been some question about whether, that's more analogous to him signing up, he had that opportunity to review the terms in connection with his prior rides. This was not the first time he had used the service.
I think it's also part of the record that he didn't use texts.
He says that, but I think that's very important, Your Honor. That's what the case turned on for the district court and what my friend's argument hangs their hat on. That is the classic example of a idiosyncratic subjective practice where this individual plaintiff says, I am the extraordinary person who, at this time in our age does not use text messaging. I categorically refuse to read. And that's a subjective practice that cannot defeat contract formation.
I may have a follow-up about that, but let's get back to not the person who doesn't use text
Okay.
when they have a smartphone,
Sure.
but the person who doesn't have a smartphone. And Uber is coming in a minute.
So even if they don't have a smartphone, Your Honor, as long as they're capable of receiving text messages, they're going to get a message. And keep in mind, this is the message that tells you what car to get into. So it's not like this is a message that you can conveniently ignore. This is
But
how
as
you,
to that, I mean, presumably the way this works is that the primary user can, and I think that's what happened here, but I could see it happening in other situations. The primary user can reach out to the guest and let them know what to look for. So it doesn't seem crazy to me that a guest wouldn't have to. And I take the point, a lot of guests are going to look and verify and all that. I don't dispute that. But if you have a situation in which the guest has a flip phone, it's not easy to leaf through a multiple page contract to find the arbitration clause, and they have a minute. And if the ride leaves, they're in the middle of nowhere, they're stuck for 25 more minutes. Uber's position is that they're bound to the terms of the contract that they were supposed to. How do they get it on the flip phone, by the way?
I'm sorry.
How do they get it on the flip phone?
Well, even flip phones are capable of receiving text messages, Your Honor. Most of them are.
I thought how do they see the contract?
Well, most flip phones are still have a connection to the internet. So I think the situation
Can I just ask, so you can click on a link on a flip phone?
absolutely, Your Honor, as long as you have a connection to the
I'm not
internet.
aware of how
Yes.
flip phones work.
Well, I think maybe we're thinking about different kinds of flip phones, Your Honor, but I think a flip phone that you can buy today in a store is capable of receiving text messages. It's capable. It has a little, trackpad where you can click on a hyperlink and it has an internet browser. Most of them do. If you are the extraordinary minority of users who you're using the Uber application, but you don't have a connection to the internet. And again, we're talking about just a extreme minority.
He's not using the Uber app.
That's right, Your Honor, but
You just said if you're using the Uber application.
he has a phone
Okay,
and
but using the app.
that's right. He's not using the Uber application. But my point is, Mr. Walker knows if he is one of the extreme minority of Americans who has a flip phone that doesn't have a connection to the internet or doesn't have the capability of receiving text messaging. He never made any of those arguments because I would be
So
surprised
let's
if they were
suppose
true.
it's a flip phone with a connection to the internet. Okay. So it's a flip phone with a connection to the internet. I don't know how great the connection is, but it's a connection to the internet. Let's just assume you're kind of out in the middle of nowhere and you got a minute. Rides come in a minute. Is the reasonable person is someone who does what?
Who reads the text message. That's all we'd ask you to do. That's all we're asking.
No, you got to do more than read the text message because you got to read the attachment.
You have to, as soon as you read the text message, if I want to take this ride, I'm going to have obligations that run in exchange for using the ride. If you click on that hyperlink within the very first few paragraphs, it's not buried. It's not the arbitration agreement doesn't appear
But
like on
suppose you
page
can't do it
20.
in a minute, and it doesn't surprise me that you couldn't do it in a minute. It's a lot to ask in a minute. Is the reasonable person supposed to say, I'm passing up on the ride?
I think if they
That's
feel
what I'm saying.
strongly about that, Your Honor, if they're like, I'm not concerned, I'm concerned about what these terms might say. I'm not comfortable taking this ride until I've had a chance to review, then yes, that's exactly what they're supposed to do as in every other situation. And again, I would just note, Mr. Walker can't make any of these arguments because he had used this same service multiple times before. He can't plausibly argue he didn't have a full and fair opportunity to review these terms before he took this ride.
Yeah, it's also the case that Uber could have done more to make sure that a person who's in a guest situation is bound to the contract that it attaches.
So, Your Honor, I think you could always say that. You could always say there's more we could imagine. Uber could have physically sent somebody with a clipboard to meet Mr. Walker to get his penning signature. But the standard under the District of Columbia contract formation law doesn't demand the most that Uber could possibly do. It asks, did Uber take steps that would allow a reasonably prudent user to know that there were contract terms? That is the standard in the District of Columbia. It is the standard in the overwhelming majority of other states. And that is this, I think we amply satisfy that standard.
Which has found contract formation under similar circumstances.
So I understand.
Unsolicited text, no actual membership with Uber or anything like that.
Your Honor, yes, we absolutely do. But I mean, I have to take issue respectfully with Your Honor's characterization of the text as unsolicited. The text came to him because it was solicited by his wife.
I know, but by him, unsolicited by him.
So I mean, I guess I would just say it was,
It's a fact-intensive inquiry, and you're trying to say that he was on inquiry notice.
yes.
So
but-
he gets a text that he, didn't ask for, didn't solicit, et
So,
cetera.
Your Honor, if he's
He's relying on his wife to tell him what the car is.
Let-
So
can I speak?
anyway, I know it's a reasonable person inquiry. I'm just asking you, what's your best case?
I think that the cases like Hamilton from the Southern District of New York, cases like Hartenstein from this district court, cases like the Hilbert case decided recently by Judge Ali, all involve users who claimed we didn't have actual notice. We didn't read the terms because I was blind, because I was in a hurry, because I didn't have my own account.
I
All
think
of
you need to be a little bit more specific than that.
So there's not going to be a case, Your Honor, where a user said, I didn't have notice because I categorically don't read text messages sent to me by the companies that I'm transacting with. But my point is, that's not a legally valid defense.
No, I'm just asking you if you have a case that says all reasonable people open an unsolicited text under these circumstances.
I think
And
it
I
is.
don't think you do.
Your Honor, can I come back to the unsolicited point? Because I think that's important.
But can we confirm that you don't have a case that supports this theory that all people open texts under these
I
circumstances?
think it is the only the standard is what is commercially reasonable. And I
No, but as I keep mentioning, it's not just who would open the text. It's a fact-intensive inquiry, which goes into the relationship you had, the type of transaction it is, et cetera, et cetera, et cetera. And I guess I'm asking you, I guess Uber's a big company. It has lots and lots of people using its app all over the country. Has any other court held that this is a contract that puts people on inquiry notice when you just send the text that says your car is coming?
Yes, courts repeat. We cite in the cases on page 27 of our brief. I think the Starkey case from the Second Circuit is
But are those people who I guess downloaded the app, accepted the terms and conditions?
Some are not. There are multiple cases involving guest riders, people who didn't themselves request the ride, who are nevertheless held to have notice.
Just because they received the text that says your ride is coming?
No, but
That's what I'm asking you. That's what I'm trying to zero in on.
Your Honor,
Because that's the crux of your argument, that text that said your ride is coming, that is the inquiry notice. Is there
Yes.
any other case that said that text is sufficient inquiry notice?
I don't have a case that fits this exact fact pattern, Your Honor. Obviously, I would give it to you if I had.
That's fine. That's what I was asking you.
The reason why we don't have it is, I think, because there is almost nobody who would successfully make the argument that they have an idiosyncratic, commercially unreasonable practice of ignoring all text
Well,
messages.
it wouldn't have to be that. It's just they didn't open that text.
You're right. And so on that point, I didn't open it. That is an argument that we see all the time, and the
Okay,
courts.
so can we zero in on that?
Yes.
Are there cases that say Uber sent the actual text that says your ride is coming now, and the client said didn't open it, but they were held to be on inquiry notice?
I'm sorry, when you say didn't open it,
Didn't open it, didn't look at it.
Didn't
look
open
at
the text message? No, there's not cases like that because, again, nobody makes that argument that I just categorically refuse to open text
But I'm
messages.
not saying categorically refuse, just didn't on this occasion.
They don't, no, people, I'm not aware of cases that fit that precise pattern, but I think it's a great example.
But isn't that the crux of your argument? That you sending the text was enough? It doesn't matter how they react to it. You're saying in every situation, every reasonable person would open the text.
Yes.
Regardless of their relationship with Uber, how many times they've ridden, the size of this transaction, all the other factors that I think other cases.
So
have
what I'm
talked
saying,
about.
Your Honor, is in the context of this transaction, Uber as a technology company, we're providing you services where we as the company are trying to tell you the car that is coming to pick you up. Here's the driver, here's the license plate.
Get that. I'm trying to understand why that text is sufficient to form a contract.
Because that's a lot of the cases have focused on things like temporal proximity. When did you put the information in front of the user? Were you trying to obscure it or hide it? Or were you trying to do your level best to get it in front of them? My point, to Your Honor, is we clearly are in the position of trying to get this information in front of Mr. Walker. We want him to know that taking this ride is going to result in agreement. It requires agreement to the terms. And the reason why is because in the message where we're telling him when to get picked up, we give him the link.
A reasonable rider might not know. If you're sending a text message that just says your driver will be here and here's his license plate number, they're not a reasonable person wouldn't think there's also going to be all this other information in here. I better click to find out. And therefore, I will be bound. And when I enter the cab ride, I'm entering a contract. I just don't think that's reasonable.
So may I make 2 points about it, Your
Yeah.
Honor? The first is the order. Before we get to telling you which car and driver is going to pick you up, the text message says, and you, by agreeing to this ride, you agree to these terms and conditions
I
provided
know,
by Hyperlink.
I'm saying something different, which is
Okay.
that I don't think a reasonable person would understand that they need to open that text in order to, before they enter the car ride, understand that what the contract is that they're entering. Like your argument seems to hinge on the fact that reasonable people always open this text. And so they're on inquiry notice of the contract because these tests always include those things. But reasonable people who are getting their Uber might not know that there's something on top of just getting the ride, that they're entering this whole contract with terms and conditions, et cetera, by getting into the car.
Your Honor,
I don't know that.
a reasonable person using the Uber service needs to open that text message in order to know the ride that's picking them up. And
Apparently not, because some people have their spouses tell them.
so I don't think that's necessarily commercially reasonable behavior, but let me speak just directly to that for a moment, because the record also reflects, as we explained, that Mrs. Walker was told that she was required to provide Carol Walker's cell phone information, his phone number, and she was told, Mr. Gaddis testified in the record, that that Mr. Walker would be provided information about the terms of use. So if you were in the unusual situation where we're relying on the wife to provide the information about the license plate, we're also telling the wife, Mr. Walker needs to know about these terms of use that are going to govern the ride. So I just think that
You're
can't.
trying
Should
to, oh, go ahead.
I mean, if she doesn't pass that along, it's hard to say that he's bound.
But that, Your Honor, I think that's commercially unreasonable behavior. If we're telling her, here's all the information you need to know about this ride. You need to know the ride, the license plate and car that's picking you up, and you need to know about the terms of use that govern this ride. If she is choosing to only pass along half of that message to her husband, I don't think that that's commercially reasonable
Would that
behavior.
also apply? So I think one situation in which you can have a guest ride is where the person has lost their phone. I mean, we've all been in a bar or restaurant or something. We misplace our phone. We can't find the phone. So we can't call Uber. So someone else calls Uber on our behalf.
And I think what you'd rely on in that situation, Your Honor, you would rely on the person requesting the ride for you to provide you with both. Hey, what car am I looking for? What's the license plate? And is it a Toyota Camry that I need to know? And is there anything else I need to know? And the point is, whoever called that ride for you in that hypothetical situation, we told them, here's what you need to know about the license
So
plate
your
of the
theory
driver.
would be, there would be inquiry notice in a situation in which the guest doesn't have an Uber account. They lost their phone, so they can't get texts. But Uber, of course, has a communication with the primary user that is taken as a given by everybody, I think, that the guest has inquiry notice even though they don't have a phone.
Yes, because we have provided reasonable means for the user to know both the ride that's picking them up, the service they're getting, and the terms and obligations that govern their use of that services. Maybe we talk about the third-party beneficiary
Well,
argument.
before we get there, I don't know if my colleagues are done. Uber has set up a system here where someone can use this service without opening the text, without clicking on anything. Just got in the car, and that's what happened here. It's just able to get in the car. It's not required that you open the text. It's not required that you click on anything. It's not required that you look on your phone to use this service. You sure hope they will, but it's not required. So why is this not the equivalent of a browse wrap?
Browse wrap agreements, Your Honor, are not invalid under District of Columbia law or the law of many other states.
What District of Columbia case has has found inquiry notice for a browse wrap?
I think Forrest is a pretty good example of that.
That was a browse wrap. Person didn't have the app, hadn't signed up for anything. No, this person did not have an account with Uber, which would have created the contract by itself, regardless of the ride.
I agree with Your Honor about
All right.
that, yes.
Forrest meets that situation, someone who didn't have a pre-existing contract with the company. and simply the company sends them a text, but they don't look at it or whatever, and they decide, or whatever form the information came from. But looking at that information is not a condition of accepting the service.
So I think Forrest is an example of a browse wrap agreement that was upheld by the District of Columbia
Under these
Court of Appeals.
circumstances where you don't have to click on anything, you don't have to, it doesn't even send like a read message back to the company. Nothing is done to show, nor is anything required of the individual with respect to that information to accept the service.
Well, I think what's required of the individual, Your Honor, is to make the decision.
No, I'm asking you about your Forrest case. I do not read that as holding. As a matter of DC law, and we have to be sensitive here. We're not the experts on that. DC Court of Appeals is. All right. Inquiry notice is sufficient, even if there's no requirement that the information be looked at, opened, read, received. No action is required from the customer whatsoever with respect to that information as a precondition of accepting the service.
So a browse.
Is that yes or no as to Forrest?
I'm sorry, I'm genuinely unsure
Forrest
how
covers
to.
this situation. I've told you the question I'm asking about. That's how I understand a browse wrap. You don't have to do anything to accept the service.
I'm very reluctant to correct, Your Honor, but respectfully, I just don't think that's what a browse wrap is. A browse wrap refers to a situation conventionally where a website says, in order to sign up, by signing up to use our service, you are agreeing to terms and conditions. And the courts that have looked at browse wraps.
Signing up to receive our services, and then the person does something to sign up.
Precisely, Your Honor. Precisely, but
That's not browse wrap. Browse wrap does not require, that might be a shrink wrap, but that is not browse wrap where you don't have to do actually anything. I mean, these are the where nothing is required of the customer to accept the service. Nothing is required of the customer to accept the service. Information might be given to them, but nothing is required. Reading, accepting, clicking, nothing is required, and they can go forward and have the service just the same as anyone else could. Those are the browse wrap agreements that have been flatly rejected by courts.
no, respectfully, I don't think that that's quite right, Your Honor. What courts have said about browse
What
wrap.
was he required, what was he required to do here that if he didn't do, he couldn't have gotten into that Uber?
He was required to either accept the service or reject it. That was.
So the door was locked until, the door to the Uber was locked. He couldn't get in until he told the Uber driver, yes, I have received this message, and clicked on the agreement.
No, Your Honor.
No, you don't make it a precondition. He got in this car without reading the text message or clicking on anything.
He claims he got in without.
That's the facts we have before us.
He claims that he got into the car.
That's the facts we have before us.
Yes, Your Honor, but
Do you have evidence that he did?
no, Your Honor, but that is an example of a idiosyncratic subjective practice, and this contract
That's the
formation
point, that
standard.
you don't require anything from them. On JA 163, what does the word bounce mean? Look at these messages.
On JA 163, Your Honor?
Yeah. What does the word bounce mean?
I'm not certain.
Well, this is about,
I'm sorry, Your Honor. I don't know.
that mean maybe it didn't even go through? Because your next pages show when things are completed. I don't even know how do we know the call even went through?
How do we know that the text message went through?
Even went through.
Well, I think
If we don't know what this bounce means,
so.
maybe this is something completely different. I just don't know what bounce means here.
I'm not sure either, Your Honor. This wasn't a point of argument between the
And
parties
then
either in
another thing
the
on
Court of
your
Appeals or in the
so
district court.
reasonable thing. No one has mentioned here what the district court found it's a factual basis for part of its decision, and that is the appearance of the message. All right. And the appearance of the message has what you all call the nuance stuff. I never knew about nuance stuff until I read this case. Maybe I'm unreasonable, let me know. I look at this something, if I got a text that looked like this, with lots of dashes, ends, I don't understand what it is, lots of letters and numbers all put together, I'm going to remember my training from our computer team here, and I'm going to think it's spam. If you look at, if we assume, I know you don't think that, but if you assume it looked like this, as a district court found what he called a mishmash of numbers and letters and other figures. And someone said, I don't have an Uber account. I know better than to click on things that look strange. That's what's one of the markers of spam or more vicious communications, harmful communications, is this mix of weird signals and things like that, where things are all smushed together. And so they thought it was spam. I look at this, I would have thought it was spam if it showed up like this. Put aside your argument as to what it looked like. If it actually looked like this, would a reasonable person click on it?
I'm going to say yes, Your Honor. And
Okay, so I'm unreasonable. I would look at that and I'd say spam.
well,
I would not click on something.
think part
I
of the
haven't asked for this message. I'm not an Uber subscriber.
Your Honor, your spouse is named in the message in the hypothetical, and your spouse
Of course,
is.
there's always information somehow relevant. That's how they get you in.
I think respectfully, it would be a mistake.
You have to win. Given the district court's findings, your facts presented to the district court judge, and the district court's reliance on your factual evidence for making this decision, you have to show that any reasonable person who does not have an account with Uber, has not agreed to anything with Uber, and gets this text with just a few minutes before the car shows up, would click on that and put me in the category of unreasonable, then click on, or would open that up to read it, and then click on a link within it, the one thing you're just definitely not supposed to do when things look strange and you didn't ask for them. And then read it and understand 11 pages of legalese, which does, and make that decision and understand I shouldn't get in the car unless I sign up to all this. That is the position you have to demonstrate to show.
Judge Millett, respectfully, that is not what the record shows. May I ask you to look at page 93 of the JA? This is the Gaddis affidavit. This is the record evidence. Okay, this is paragraph 17. Now, you are right, and the district court focused on the fact that Mr. Gaddis in paragraph 17 in the first sentence.
Slow down for me here. I got to get to the right page here.
JA 93, Your Honor.
Yep.
Okay, so you're right. In the first sentence, Mr. Gaddis explains the coding, but keep reading. 2 sentences later, Mr. Gaddis
Sorry, which
explained.
paragraph are you in?
I'm in paragraph 17, Your Honor.
Mhm.
2 paragraphs later, it's 3 lines up from the bottom of the paragraph. Mr. Gaddis explains in the record evidence that went to the district court how this text message looked. What did we say to Mr. Walker? The text quote, the text message expressly stated that by taking this trip, you agree to the Uber terms of use and privacy policy.
Yeah, but that was the district court acknowledged that. We need to be fair to the district court here. But the district court said that sentence was buried in this mishmash of information here. And that's the problem. You can't get away from that.
Your Honor, I think this is.
If Uber actually chose to send things out with all kinds of symbols and letters and numbers and things all put together and has a nice little link in the middle with one coherent sentence, then everybody is automatically bound by that, even if people concerned about spam from unsolicited text messages wouldn't click on it.
Judge Millett, I think it would be a miscarriage of justice to decide this important case based on a factual misconception about how this text message
Whose
looked.
misconception?
It was the district court's
I think
misconception.
that is quite unfair. That is quite unfair. This is the information, this was your evidence. Somebody may be messed up, but this was your evidence. The district court said, reproduced it line for line for line as presented in your evidence. All of it. Acknowledge what you said about the hyperlink. And you say, oh, judge, silly judge.
No.
You just said a misconception, an erroneous conception by the district court judge. You erred in taking us at our word and thinking we meant what we said.
Your Honor, I think we attempted to tell that there was no factual dispute about this issue in the district court. We did not know. If we had known.
You mean no factual dispute? There's nothing. You're right. That's exactly right. You put it in and said, this is the message he received.
Well,
you put it in. This is the message he received. Of course, there's no factual dispute. Our district courts, do they engage in error and misconceptions when they accept as given evidence presented to them by a party?
The plaintiff did.
Do district courts error, engage in misconceptions when they accept as given the evidence presented to them by a party?
I think that.
Do they, yes or no?
No, as a general
Okay.
matter, but
No, it's a general matter. No. You don't, the word general. Either they do or they don't.
I don't think district courts can be faulted for relying on the evidence that the parties put forward. But I
In the
think that
form presented to them.
I think the district court had an obligation to look at the entire paragraph 17 and under the party present.
He did. No,
But
you cannot criticize our district court judge for that.
it's, Your Honor, I'm not
He
criticizing.
recognized it. He says in his opinion, yeah, that hyperlink was in there, but the problem is the presentation.
Your Honor, the question.
Confusing. And people have got a few minutes here. First, they got to figure out, what is this? Why do I have, if they happen to look at all, and then they've got to look at it and go, what is this? Should I open it or not? I wouldn't. And then if they choose to, they've got to go navigate through this information that's unreadable and yet click on this link. And then they have to, on their phone, read 11 pages of single space, fine print, full of legalese that never actually directly says it's, we could debate for a long time the legal proposition of whether the content of that document put him on immediate notice that he was agreeing to arbitration. So you tell me, it's not enough to say any reasonable person would open a text message that looks like this and then go to the middle of it and click on a link when it's not necessary. I'm closing my phone, car shows up and I get in, and nothing Uber has set up in this process that it designed requires any confirmatory or acknowledging action on my part.
May I make two responses to that, Your Honor? The first is I do want to talk about the important issue of the idea that the terms of use were 11 pages and that it was obscured. If Your Honor takes a look, as I know you will, at the record with the terms of use, you will see that the arbitration agreement is presented right up front. It is literally one of the first things that is presented. This is at JA 122. It is the paragraph that's in all caps and bold. That's not the most important point, though, but I think that the point there is just to say that anybody who opened up this terms of use and even just glanced at it in a little bit is going to see this bolded paragraph that says you need to be aware that there's an arbitration agreement that's going to govern how disputes between you and Uber can be raised.
I mean, we can do this if you want. I've already looked at it. I don't think it's where this case rises or falls on, but the services, all right? The service, I'm only agreeing to anything, a contact regarding the services. And then the services, where are they defined? Got go over a few more pages. We get marketplace platform and services. That's about using the website. Third-party services and content, that applies to Ms. Walker. Access and use of the services, that's the best you're going to, but it never talks about, it never says if you get in the car, if you're a third party, it never says if you're a third party. It requires inference about what these services are, and that gets back to what the district court talked about, is even taking your reading. It's not clear.
Your Honor, this is a really important point. Can I ask you to look at JA 123, please? It's about, it's under within 2A. It's the third paragraph in there. This is the critical part of the arbitration clause. I mean, this arbitration agreement shall be binding on and shall include any claims brought by or against any third parties, including but not limited to your spouse's third-party beneficiaries. To the extent that it goes on to say, to the extent that any third-party beneficiary to this agreement brings claims against the parties, those claims shall also be subject to this arbitration agreement. I think that is a
Claims in
clear.
relation to your use of the services.
Yes, and the services are the transportation
Is that different?
services.
Where's that definition?
I'm sorry?
Where's the definition?
It's on JA 125 and 126. It's the definition of the marketplace platform and services. And it says that the services consist of the marketplace platform, the matching
So
service,
that's what
and the
the
providing of
app-
transportation
That's what
services.
the app allows you to do, but he wasn't signing up.
Your Honor, I
He wasn't
think if
downloading the app.
Mr. Walker is clearly a user of the services that Uber is providing. Uber is providing the means for him to get connected to a transportation provider to get a ride. This is also why he is an intended third-party beneficiary. It's very important to talk about this argument because even if you disagree, or even if you agree with the district court's conclusion that he didn't have inquiry notice, he's still bound under both principles of third-party beneficiary law and estoppel. And I want to talk for a moment about that estoppel argument because
Well, let's go back to this third-party beneficiary thing. First of all, again, the reason we want to talk about this is because it's not crystal clear, at least to me. Maybe ultimately the contract would be interpreted the way you want it, but on a read by me, in more than 10 minutes it took for his car to come, it's not crystal clear how this, what happens here to people who don't actually have the Uber account and someone gets a ride for them. It's just not laid out. And it's not only laid out, it's omitted. There's talk about minors, right? But there's no talk about adults in the agreement.
I think that all you need to know in order to know that Mr. Walker was bound by the terms of this contract is that he was using Uber's the transportation services that Uber is providing. And he clearly was.
Which I think if he understood what the services meant under this contract, not colloquially, what they meant under this contract. But I'm sorry, you wanted to talk about
Estoppel, Your Honor, because even if you don't find that he's a third party beneficiary, so it's common legal.
Well, do you agree that DC Court of Appeals law is crystal clear that third party beneficiary is a basis for someone to sue you because they are part of the contract, but DC Court of Appeals has held that it doesn't work the other direction.
Absolutely do not agree with that, Your Honor. That is my opponent's argument. I think it's quite wrong. I would urge the court to take a look at Judge Boasberg's decision in Hartenstein.
What's your best case from the DC Court of Appeals?
Yes, so I'm going to give you three: Fort Lincoln, Fairman, and Thorborn. These are all cases cited in Judge Boasberg's opinion in Hartenstein and Judge Bates's opinion in the OM case. That's OEHME. These are both DC, obviously district court cases that are applying DC territorial law. They are citing Fort Lincoln, Fairman, and Thorborn. Now, the holding of those cases, and this is agreed between the parties. You can take a look at page 48 of the red brief where my opponent cites Thorborn, and they say exactly the same thing. Here's the legal standard that both parties agree on. A non-signatory is bound to arbitrate if he knowingly seeks and obtains the direct benefits from a contract, seeks to enforce the terms of a contract, or asserts claims that must be determined by reference to that contract. That's a quote.
Right. That's essentially the estoppel argument.
Yes, it is.
If you seek to, okay, but that's different than third-party beneficiary.
So
I asked you a third-party beneficiary question.
So, Your Honor, I don't think
you want to do equitable estoppel.
I do want to do estoppel.
Okay.
I want to do both, Your Honor, but may I complete the estoppel point for just a moment? And then okay. A non-signatory is bound where they assert claims that must be determined by reference to the contract. Again, that's a quote from the DC Court of Appeals in Thorborn. My opponent has it at page 48 of the red brief. That situation applies here. Why? Because of the complaint at JA 33, paragraph 160K. Mr. Walker pleaded. He says that Uber, I'm sorry?
Where is this in the JA?
JA 33, Your Honor, paragraph 160K. So Mr. Walker alleged in his complaint that Uber, through official communications, Your Honor, I would urge you'll need to read the whole paragraph to sort of get this, but it's broken up along multiple subparts, as you can see. But here's the allegation in the complaint. Here's the claim. Uber, through official communications, represented to their customers, including plaintiffs, including him, Mr. Walker, that Uber drivers are agents of the Uber defendants and that their care and skill are carefully vetted. So he says, I relied to my detriment on that. The only way for the court, the district court, to evaluate that claim is to turn to the official communications that Uber provided in the terms of use. Now, of course, the terms of use are going to actually turn out to say
the estoppel argument isn't that contract might be one piece of evidence in a case. The estoppel argument is when someone sues on the contract. There is not a contract claim in this complaint.
Your Honor,
This subparagraph you referenced to is under count 3, negligence a parent agency.
Yes, but he's saying that the negligence was because he relied to his detriment on Uber's official communications. Those official communications occur in the contract. That's how we officially communicate. So his
But also through advertising campaigns.
Yes, also, he has other theories as well. But the point is, there's no way to adjudicate this claim, to know whether we as a company misrepresented the legal status of drivers. There's no way to know that without looking at the terms of use where we talk about the status of our drivers. And so it's precisely because Mr. Walker is here in one breath saying, I want to talk, I relied on Uber's official communications, meaning the terms of use. Because he wants to invoke that contract as a source of legal duty, he cannot turn around on the same hand and say, but I disclaim any obligations running the other way. That's the core principle of estoppel recognized
All right, but
under
this
DC Court of Appeals
count
law.
is, do you have a case, equitable estoppel has always been applied, as I've seen it, when someone is suing on the contract. That is a contract claim for relief. If you have a case from the DC Court of Appeals that says it's sufficient that the contract could be one of multiple sources of evidence for a tort claim, what's your best case?
I have a case that says that where a party asserts claims that must be determined by reference to the contract binds them. That's the DC Court of Appeals decision in Thurburn. It is, what I read you is just a quote from that.
So that's a tort case where they relied on a contract term and then the contract binds them?
I'm not sure I can't remember off the top of my head whether it was a tort case, Your Honor, but keep in mind, these are general principles of contract law. This is not like an esoteric area of the law. The DC Court of Appeals has applied the restatement of contracts.
But it wasn't a contract claim. I mean, I think the point is whether it was
Yes.
tort or not, it was not a contract claim.
I'm not certain off the top of my head, Your Honor. I can't remember, but I know that the Hartenstein case, Judge Boasberg's decision, that's a decision against Uber. Judge Boasberg, in that opinion, is making the same essential point and he's quoting the DC Circuit, the DC Court of Appeals decision in Thorburn. So again, I just think that's the application of a conventional contract law principle found in the restatement that multiple courts of appeals all around the country have accepted, as we explained in our brief, this idea that guest riders are bound. You're not breaking new ground. Indeed, for this court to reject that theory would be going overwhelmingly against the sort of the tide of cases that have addressed
You do a
this.
whole lot with equitable estoppel in your brief, in your opening brief, but I'm not suggesting you completely waived it. Where did you cite to this paragraph?
I'm sorry, where did we cite to which
Where did you
paragraph? Your Honor?
cite to this 160K, subparagraph 160?
I'm not sure that we cited that particular paragraph, but we certainly made the
Did you
point.
cite a particular part of the complaint as invoking a contractual argument?
Yes, I'm quite confident, Your Honor, that we
All I remember you saying is you can't claim the benefits without the responsibility.
We did make that argument. We also made the argument that you could not assert claims that needed to be decided by reference to the contract and then disclaim your obligations under the contract. That's in both our opening brief and in our reply brief when my friend said you need to separate the difference between third-party beneficiary and estoppel. Of course, as we explained in the reply, there's multiple cases saying that's a really thin distinction. Any suggestion that this was waived below is, I think.
That's not why I'm asking the question.
Okay.
I'm asking where you pointed to, and maybe you have other parts of is that your only part of the complaint that you think references?
No, I don't think it's the only part. I think
So
it's.
I'm just asking where those were argued to us in your opening brief?
Your Honor, I don't have the briefs
You can
at
on
the
rebuttal.
lectern, but I'd be
So-
more than happy to provide them on rebuttal.
So for this part of your argument, you're not relying on the notion that by accepting the benefits of a contract, you're bound to the contract. You're saying the plaintiffs did not just accept the benefits of the contract. They referred to the contract in the complaint.
That's right. They're different arguments, Your Honor. No, I believe both are true. Certainly, as Your Honor is alluding to, we have forcefully argued that Mr. Walker accepted the benefits of the contract. He took the ride, and he did so knowingly, and he did so after Mrs. Walker was informed through the contract that she would have the opportunity to get services for third parties, and that third parties, bringing any claims in connection with her use or their use of the services would also be subject to the same arbitration clause. That's the essence of the third-party beneficiary
Even
argument.
if you don't have inquiry notice.
Even if that's exactly right, Your Honor,
That's the
you
whole
do not.
premise of it. I mean,
That's exactly correct. That is
Yeah,
correct.
that's-
So really you have three independent reasons why Mr. Walker is bound. He's bound because he received inquiry notice through a text message that put a reasonable person on notice, and his idiosyncratic defense that he chooses not to read text messages does not defeat the objective standard. You have contract formation because he's a third-party beneficiary when he knowingly accepted the benefit of the services with and knowledge through his wife's agreement that he was a third-party beneficiary who would be bound to arbitrate specifically. And third and finally, you have contract formation because he made arguments in the complaint that require referencing the contract, and he cannot simultaneously invoke that contract as a sword, but say none of the other obligations on him apply.
And all three of these theories would apply in all the factual scenarios that we've discussed. Meaning regardless of whether you in fact happen to have a phone, regardless of whether the ride's coming in a minute, it's all three of these theories would apply.
Your Honor, I'm not sure I can say that respectfully, just because I think each theory turns on the factual record that you have. They all apply here, and I wouldn't ask, I don't think the court should venture into saying this is, how these contract formation principles would apply in all factual settings. I think all we
No, it
moved
wouldn't be
on.
all factual settings, but the scope of the theory, obviously,
Of course.
of course it matters to courts, and we've got to understand the rule that you're pressing upon us.
And I think the only rule that we need, the rule that your Honor should pronounce is where a company like Uber takes steps to put a reasonably prudent user, to quote Judge Moss, on notice of the terms that are going to govern his or her use of a commercial service. A user who accepts those terms by their contract, which my friend agrees is a perfectly legitimate way of manifesting assent under District of Columbia law, a person who accepts those terms is bound by the terms and cannot later claim that they have an idiosyncratic practice to categorically refuse to read the information that's presented to them.
Make sure my colleagues don't have additional questions. Okay, thank you,
Your
counsel. We'll give you a little time for rebuttal. Slayton.
Good morning, Your Honors, and may it please the court, Shelby Layton for appellee. Carol Walker has never downloaded the Uber app or had an Uber account. Despite that, Uber argues that by simply getting into an Uber called by his wife, Carol waived his right to a jury trial in court and must arbitrate his claims. The district court correctly rejected Uber's attempt to reshape basic principles of contract law. I'll start with the formation issue. Uber is essentially saying that a user can be bound to a contract based on a text message they didn't have to open, view, or interact with before getting in the Uber. In the online contract formation cases, courts engage in two levels of inquiry. The first inquiry is whether a reasonable consumer would have necessarily seen the reference to the terms while completing the transaction at issue. So for example, if the consumer has to scroll to a different part of the page to see the terms that they don't need to scroll to click a button or complete the transaction, courts have said that's insufficient to form a contract. Conversely, if the information is right next to the button that the user has to click, and they must have necessarily seen that information while clicking the button, courts uphold that as sufficient notice. It's only then, once you determine what the consumer would have necessarily seen, that you look to whether the language and formatting of that information is sufficient to put the consumer on inquiry notice of what the actual terms of the contract are. And so if you apply those cases here, the threshold question is whether Carol would have necessarily seen the text message from Uber before he got in the Uber. And the answer to that is clearly no.
Right. Why is the test whether he necessarily would have seen it?
So
Whether reasonable third-party customer would see it.
it's whether a reasonable person would have necessarily seen that as part of conducting the transaction. So in cases, browser app cases, for example, like the SPECT case from the Second Circuit, which is one of the original browser app cases, the court looked at the fact that what the screen looked like to the consumer and whether a reasonable consumer would have necessarily known that there was a reference to terms somewhere on the page. And because they wouldn't have, because they would have had to scroll down to see that, the court said that was insufficient notice. In the Marshall v. Georgetown case out of the Fourth Circuit, it was the same thing. So would the person have necessarily had to see the reference to the terms? No, they could complete the employment application and submit the application without ever looking at the terms. And so that's insufficient to provide notice. The same thing is true here. Cheryl or any reasonable consumer can get in the Uber and complete this transaction without ever having to see the terms. And what Uber could have done here is make it so that they did have to see the terms before they get in the Uber. Uber could have required them to reply to a text message or click on something in the text message in order for the Uber to be dispatched to them. It could have sent a PIN in a text message, which is what the companies did in some of the cases that Uber cites, where you would then give the PIN to the driver from the text message. And all of those things would require that the person actually has to open the text message and read the text message before they get in the Uber. Uber didn't do that here. And so you have a situation where a reasonable consumer is not necessarily going to see the text message before completing the transaction. And I think it's worth pointing out here that Uber knows how to do this because it did it with Cheryl. It for people that have the Uber app, unlike Cheryl, it requires them. It has a blocking screen that says you can't order an Uber until you accept our update to our terms of service. So it knows how to make it a condition of the transaction, but it doesn't do that for guest riders here. Unless there are no more questions about that.
If the text had just said, if the text had just been a direct text, let's assume it was plain readable text. And it just says, if you accept a ride from Uber, you are bound by our contract attached at this link. Would that be sufficient?
No, but I don't think that this turns on what the text says. The focus is on whether someone would need to open the text before taking the ride. So if you have the situation where the Uber is coming in 1 minute and your phone's in your pocket, you don't necessarily see the text at all. Or in the example where you've lost your phone, someone's calling an Uber for you. Again, you're not seeing the text at all. And Uber is not doing anything to require that you see the text. And I don't think it is reasonable to expect that any consumer would necessarily have their phone out and be opening all their text messages in the few minutes before an Uber arrives. And the way to address that problem is to require them to do something with the text message before they get into the Uber. If there are no further questions on the formation point, I will.
Yeah, I'm just trying to understand the line between your argument and you argue that actual notice. You have to actual notice before there's inquiry notice. And it's not clear to me that that's DC law. And yet it seems to me that your argument is requiring actual notice. They have to see something, they have to do something that you would only do if you saw the document itself. Check a box, send in a PIN, whatever.
Right. I mean, I think there's no question that inquiry notice is required here. But the question is when the inquiry notice comes into play.
Notice before inquiry notice.
Right. So, I mean, the definition of inquiry notice is that you have actual knowledge of circumstances that put you on notice to inquire further. So the actual notice thing is sort of baked into the inquiry notice standard. But I think, again, in these cases, there's this threshold inquiry of what would a person have seen? And then there's the second question of assuming they saw that, would that have put them on inquiry notice of what the terms of the contract were? And so the threshold question, I think you can look at that threshold question as sort of an actual notice standard because it's essentially an evidentiary question.
You don't need actual notice of the contract terms. I mean, I think that's the difference.
Yeah.
You don't need actual notice of the
We
contract.
100% agree that you don't need actual notice of the contract terms. The question is, there's just two steps here that I think Uber is conflating into one step. So once he's looking at the text message, the question is the language of the text message sufficient to put you on inquiry notice of what the actual terms of the contract are? But before you get to that question, you have to show that the person would have necessarily seen the text message that would then put them on inquiry notice of what the terms are. And that question, I think, is courts have treated it as somewhere between sort of an actual notice standard and like an inference of actual notice. So where courts, for example, if someone says, I don't remember seeing that language on the screen, but courts say, well, it was right next to the button you clicked. So we're going to assume that a reasonable person would see that and that therefore we're going to analyze the language and whether it put you on inquiry notice of the contract. So I think that in this situation, you first have to look at would Carol have or would a reasonable person in Carol's situation have necessarily seen the text message despite him saying subjectively, I didn't see the text message. And the answer to that is no, they wouldn't have necessarily seen that, nor did Carol, in fact, see it himself. And because of that, you don't even get to this second step, which is, did the language of the text message put someone on inquiry notice that what the terms of the contract actually were? So I can.
And like his wife telling him, do most users, they can only know which car to get into by looking at the text message? Is that correct?
I don't think that's correct, Your Honor. I mean, in this case, his wife told him, in many cases, you have a situation where, if you've lost your phone, you might be standing right next to the person who's calling the Uber for you. I think you could also just
anytime
presume
for you could rely.
Anytime someone's, you could rely on that person to tell you, which is this whole situation is just when someone's calling you an Uber. I think there's also just the inference that like if a car pulls up in front of you and stops and like that it is an Uber and you could, they have the little Uber signs and stuff like that. I don't think you would necessarily need to know specific information about the car.
When you open the door and they say his last name and you say, yes, that's me.
Yeah, exactly. And I think I think that depends on the circumstances, but it's certainly not the case that someone would necessarily need to look at that information. I mean, you think about calling a taxi or a car service, another type of car service, you don't necessarily get a text, but people sort of figure out how to identify it. So yeah, I think that even if a person could look at the text to get that information, the question is whether someone necessarily would need to look at the text before getting in the Uber. And again, they don't, Uber has done nothing to make that required. I think the other thing that's important here, even if you're looking at a reasonable consumer's expectation, is that if you have someone else who has an Uber account, they have an Uber account and they've called an Uber for you, you expect them to be the one with a contract to Uber. You don't expect that, that you are being asked to contract with Uber. And again, an example of that would be if, I go out to dinner with my spouse and they make a reservation for us on Open Table. I go to the restaurant. I don't think that I'm bound by Open Table's terms just because my spouse is making us a reservation using their Open Table account. And this is sort of the same thing where you're not expecting to be bound by a separate contract when someone who has a contract is doing the whole transaction. I can move on to the third party beneficiary or non-signatory enforcement.
Can you address their equitable estoppel argument that there's a reference to the contract in the complaint in a negligence count?
Sure. So first of all, you are correct that they only raise that in their reply brief. They don't raise that argument in their opening brief, and even in their reply brief,
Do they cite to that provision of the complaint in their brief?
they do cite to the complaint in their reply. But let's see.
That's okay. We can figure it out later. I mean,
Yeah, sorry, I don't have it exactly. I know that they make a couple arguments based on the complaint in their reply brief. But first of all, in terms of that particular argument, the reference to official communications by Uber is not intended to refer to the contract. It is intended to refer to representations that Carol actually saw and that Cheryl actually saw. So I don't know where they're getting the leap from official communications by Uber to the contract itself. But certainly his negligence claims do not require reference to the contract. But I think just
reference to the contract enough for equitable estoppel? From the cases I've seen involve a suit on the contract.
That's right. So I think
maybe it's broader than that in other jurisdictions or other cases.
I think that I agree. I think it requires seeking to enforce some part of the contract. And I think you could have a situation, I think the reference to the contract is really referring to a situation in which maybe it's not a breach of contract claim, but it's centered around the contract. That's definitely not the case here. And in, as the court pointed out in the Ohm case.
What is the source of legal duty here?
The source of legal duty is common law duties of care, not contractual duties. And yeah, I think that it's a really important point because even the Ohm case that they cite recognizes that under all three of those different ways that you can have equitable estoppel, they all involve, most of the cases involve enforcing a contract or suing under a contract. And that's just not at all the case here. I also.
Do you, if you have to sue on the contract, do you think then that equitable estoppel principles range more broadly than inquiry notice? If we're talking about a contract action anyway, then it seems like inquiry notice could naturally come up because we're talking about the contract. Then does equitable estoppel range? Is the circle bigger than inquiry notice? Or I'm just asking.
I'm sorry.
That doesn't make sense.
I don't know if I understand the question. So you're asking.
So if
does he have to if he's going to rely on what it says in the contract, does he have to have inquiry notice of what's in the contract? Is that what you're asking?
Right. In other words, if he brings a claim that's on the contract, and which I think is your exchange with Judge Millett indicated was a precondition to reliance for the other side to rely on equitable estoppel. If we're in that land, then does the principle of equitable estoppel allow for holding the claimant to limitations in the contract, even if inquiry notice isn't satisfied?
Well, I think that's the big picture problem here is that he didn't form a contract, which is why he's not bringing a breach of contract claim. And it would be likely inconsistent for him to argue both that there was no contract and bring a breach of contract claim. And that comes up in these cases and is why maybe Uber is conflating third-party beneficiary and equitable estoppel, is because in some of these cases, what happens is that the person trying to enforce the contract has to argue that they're a third-party beneficiary of the contract so they can enforce it. And then the court is saying, well, now that you've done that, you can't you brought a claim under the contract under a third-party beneficiary theory, you can't now avoid another part of the contract. That's not what's happening here. He is not arguing in any way that he can enforce this contract or that even a contract exists in the first place. And so this is different from those cases. But in any event, he's also not seeking, he's not seeking to bring a claim that has any relation to this contract. Or, I think the other point here is that he doesn't have any rights under this contract, even assuming that he could somehow enforce it. He, as a guest writer, is not mentioned in this contract at all. All the rights in the contract are about Cheryl. And so it cannot be that he's seeking to somehow benefit from a contractual right because he has no contractual rights in this situation.
Make sure my colleagues don't have additional questions.
Thank you.
Thank you, counsel. Mr. Houston, we'll give you 2 minutes for a rebuttal.
Thank you, Your Honor. A couple of points. Judge Millett, I promised I would tell you where in our opening brief we cited the various provisions of the complaint that we think give rise to estoppel. You can find that at pages 46 and 47 of our blue brief. It starts at the bottom of 46. It goes on to 47. You'll see multiple citations to multiple paragraphs of the complaint that we think require referencing the contract in order to adjudicate these claims.
Sorry, you just helped me here. 46. You said 46 and 47?
Bottom of 46, it goes on to 47, Your Honor. Most of it is on 47, including the key language that I quoted to you in my opening provision of the argument appearing at paragraph 160 of the complaint. You see that in the fourth line of page 47. So it's definitely in our opening brief. We also argued it in terms of both third-party beneficiary and estoppel in the district court. You can see that at page JA 83. The inquiry...
I'm sorry, just give me a second here. You say that both Cheryl and he, this is about whether the driver's an employee?
I'm sorry, Your Honor, I'm having a hard time hearing you.
Sorry, that's my fault. This is, the first one is whether the driver is an employee of Uber or their agent.
Right, but...
And then...
whether they understood them to be, whether the plaintiffs understood them to be their driver or agent. And that's the claim here. The plaintiffs were saying we were deceived by Uber about whether he was an agent. And that was because of the communications from Uber in the complaint. The third party standard.
Their duty does allege a duty to them, but that's, I mean, you reference that, but it alleges that under DC law.
Right. But I think, Your Honor, the duty that they are alleging here comes from the complaint. The only way Carol can allege that Uber owes him any duties at all is because of the contract that was formed between Cheryl and Uber. That is the source of any duties that he is alleging. That's the only reason he has any relationship whatsoever to Uber. And the point of the third party beneficiary cases under the district's law is you cannot simultaneously...
It's not relying on the contract necessarily if he took the ride. Like, what if my friend calls an Uber and I just get in the Uber with them? I'm not a third party beneficiary in the way that Mr. Carroll is, but there's just a general duty of care. It's a negligence duty.
Well, but that gets the difference between the two strands, Your Honor. So when we're talking about estoppel, that does turn on the specific claims that Mr. Walker chose to plead. And I think what I'm saying and what we said at page 46 and 47 of our brief is because he chose to plead claims that require, to use the words of the case law, reference to the contract, he cannot simultaneously disclaim the obligations under the contract. If he had pleaded more narrowly along the lines of what Your Honor is suggesting, he would still be a third-party beneficiary under the clear terms of this contract because of the provision that I quoted to Judge Millett in the opening argument, where we clearly referenced third parties that are going to have access to the services through Cheryl's account. And we said unambiguously, those third parties are going to be bound by the same arbitration clause.
So do you have a case about this reference to the contract as opposed to a claim under the contract?
Yes, I do, Your Honor. So
It's not Thuberon, is it? Because we can't see it in that. Or where in Thuberon are you saying?
I would urge the court to take a look at the Ohm case, OEHME. This is Judge Bates's decision. He's quoting here, a non-signatory may be bound to arbitrate if he or she knowingly seeks and obtains direct benefits from the contract, which Carol did, seeks to enforce the terms of that contract, or asserts claims that must be determined by reference to the contract. That is the case law that we're applying here in
What was
this.
he citing? Because he's just a
He's
district court.
quoting from a Fifth Circuit decision and also a Second Circuit decision. But again, we're talking here about general principles of the restatement of contracts. No one has argued that the district's law doesn't follow the general principles.
No, I understand. It's just that I think what we're all a little bit unsure about is whether the claim has to arise from enforcing the contract or whether it can just reference the contract.
I
And
understand.
I don't think that's clear in the restatement.
I understand that, Your Honor. I mean, I think respectfully, if that's where we get to in this case, it may be appropriate to certify it to the DC Court of Appeals if we ultimately, if the court ultimately thinks that the law, that this turns on what the DC contract law turns out to be. And if you find it to be an unsettled question, my reading of the DC Court of Appeals cases is that they apply restatement principles, and numerous courts, not only Judge Bates, but others have applied these principles both in the context of the estoppel argument and in the context of the third-party beneficiary. And again, that would be cases like Hilbert, Hartenstein, the Hamilton case from the Southern District of New York, all of which involve what you might call classic guest rider situations where somebody joins in an Uber ride. And the point is, you are knowingly using the benefit.
The third-party writer downloaded the app.
That's true, Your Honor, but that wasn't the basis of the court's decision. Same thing as
Hartenstein was trying to arbitrate. That's what the dispute was about.
understood, Your Honor.
Under
But
the terms of the contract.
Hamilton, it was the reverse. Hamilton was a case where the agreement was being enforced against the rider, very much like this one. And again, I mean, there are dozens and dozens of these cases that we cite numerous ones in our brief. The
Let me
courts,
ask you because you pointed to paragraph 160 subsection K of the complaint. That's the one you pointed to as referencing the contract?
that's not the only one, Your Honor. The others are noted at
I mean,
page 47 of our brief. I think that's the clearest one, but there are other paragraphs that reference the complaint as well, I think.
Trying to enforce language in the contract.
I think they are saying language, I'm sorry.
It might save us some time here if I just go it's a long complaint, lots of negligence counts and other court counts. If we found that one part of one count or a subpart of one count was in fact seeking to enforce the contract, does that mean the entire tort case has to get arbitrated, or just that one piece gets severed off for arbitration?
It means the entire case has to go to
What says
arbitration.
that?
I'm sorry.
What's your best authority for that?
Well, I think that's the clear import. I think that's the Supreme Court's case law on delegation clauses, which there is a delegation clause in this agreement. So as soon as you find that there was a contract formed, and estoppel is a means of creating a contract, Mr. Walker agreed to a delegation clause that says all issues of scope are delegated to the arbitrator. And as this court knows from the Supreme Court's multiple precedents on this topic, that really has to be rigorously enforced. So as long as we have a contract between Mr. Walker is bound by the arbitration clause, the delegation clause will require all other scope issues to go to the arbitrator. Now, he might win that argument before the arbitrator and say, really, the only thing that should be before you, Mr. or Mrs. Arbitrator, is my claim that has reference to the contract. And I don't mean to correct, Your Honor, but it's not a claim seeking to enforce the contract that goes to arbitration. It's not just that. It's any claim that has to be decided by reference to the contract. That's when estoppel kicks in. So he might win that argument in front of the arbitrator, but it's going to be the arbitrator that has to decide it. On the inquiry notice point, if I might just ask the court to take a look at your own decision in Selden. Here's what this court said is the inquiry notice standard, because I know my friend spent some time debating that, and there's obviously a legal disagreement between us about what it is. It is not about actual notice, either of the contract terms or even the notification prompt or the hyperlink. Inquiry notice, this is a quote from Selden, this court. Inquiry notice, also called constructive notice, So right there, you know it's not actual notice. Constructive notice turns on whether reasonable people in the position of the parties would have known about the terms and conduct that would be required to assent to them. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission. We take a brief break.
Stand, please. This honorable court is again in session. Be seated, please. Case number 25-1047. Thrivent Financial for Lutherans and Thrivent Investment Management, Inc. petitioners versus Securities and Exchange Commission. Mr. Kay for the petitioners, Ms. Parisi for the respondent.
Good afternoon, counsel. Mr. Kay, please proceed when you're ready.
I had to raise it a little bit. Oh. Your Honors, good afternoon, and may it please the court. I would like to reserve 3 minutes for rebuttal. The rulemaking petition that Thrivent and Timmy filed with the SEC presented a facial challenge to FINRA rules. Those rules clearly are not consistent with federal law. That is because they prohibit FINRA members from agreeing with their customers to resolve disputes in arbitration on an individual basis in the arbitration forum of their choice and using the arbitration rules that they choose. The Supreme Court has been clear that restrictions like these can only be imposed where Congress has expressly given the agency that power. But the federal securities laws provide no such congressional command, and the FINRA rules are therefore invalid on their face. The rulemaking petition explained all of this in great detail, but the SEC denied the petition without addressing any of it. Instead, the SEC ignored the petition's merits, a point that the SEC acknowledged in its response brief. In so doing, the SEC abused its discretion in 2 distinct ways. First, settled precedent applying the APA requires an agency to provide some reasoned response that addresses a petition's merits, even if only briefly. Here, the SEC clearly abused its discretion by denying the petition without addressing the merits to any extent at all.
Is that true that they have to address the merits? Because it seems to me that there are some cases that say, it's not an agency priority, it's a resource allocation issue. Maybe you need to say more about that, but you can do that and not address the merits, can't you?
Your Honor, I don't believe that that's correct, especially in the context here where the petition presented a challenge of validity of the rules, whether they were legal. The SEC did not cite a single case that held that the agency cannot address the merits to any extent whatsoever. And we didn't identify any cases in our research that hold that. The court's precedents require a reasoned explanation, a reasoned response. And here, the SEC's response was conclusory, and to use the court's terms from the first Flyers Rights decision, it was vacuous.
I'm just looking at cases like Exhaustless and Wild Earth Guardians, and the EPA would say things like, we have other rulemakings in progress. We concluded that in light of these constraints, we're going to prioritize other sectors that emit more air pollutants. Like that seems like they declined to address the merits of the petition.
Well, and 2 points, Your Honor.
Yeah.
First off, that's not what the SEC did here. Here, the language was entirely conclusory.
Yeah, I agree that perhaps that language was not enough, but it just seems, I guess I'm trying to home in on your assertion that they have to, in some form, address merits.
Understood.
Because it was my understanding that they did not necessarily have to. They could rely on these other types of issues, but they would have to say more about those issues.
And so I understand Your Honor's question. And with regard to the Wild Earth Guardians case, the agency did invoke its resource allocation, but it did so in addressing the merits. So the merits of the petition related to the regulation of greenhouse gas emissions. And so there, the APA explained, here is what we're doing to address and curb greenhouse gas emissions. And so we're using our resources to address other sources, electricity generation, motor vehicles. That accounts for 60% of greenhouse gas emissions, whereas coal-fired power plants represent 1%. And so in that way, we are prioritizing our resources, but we are addressing the merits and saying the merits of your request, which are address coal plants, is less pressing to us than these other factors of greenhouse gas emissions. So even there, the agency did take on the merits of the request in saying our resources are being prioritized for other areas where greenhouse gas emissions need to be regulated. I would like to address the second way in which the SEC abused its discretion is that here, this rulemaking petition identified rules that are unlawful on their face, and the SEC failed to correct them. The commission has long known that the federal securities laws provide no authority for the arbitration restrictions that FINRA's rules impose. And instead of addressing this issue, the SEC here, in the context of our rulemaking petition, has conducted a campaign of avoidance that has gone on now for nearly 4 years.
Why do you, why do you say the SEC knows that it has to allow your arbitration agreement to displace the FINRA one?
Well, Your Honor,
Maybe I misheard you.
I understand.
Put words in your mouth. Tell me.
Well, this rulemaking petition presents a facial challenge to FINRA's rules. So the question is not whether the commission is required to allow our arbitration rules to be imposed, but whether the FINRA rules are consistent with federal law. And this presents a facial challenge. On that point, absolutely.
You have to run you want us to view this as a facial challenge, so you have to run the board that there's no situation where a private arbitration agreement could displace the FINRA.
Again,
not displace.
Right. And again, Your Honor, there's no issue presented here. This is the way the SEC tried to frame it in their brief. Absolutely.
I'm asking you what you mean by your facial challenge here.
Understood. So just as in the Supreme Court's Epic Systems case, where the Supreme Court held that the National Labor Relations Board's rules prohibiting employers from agreeing to resolve disputes individually in arbitration, the Supreme Court held that restriction exceeded the NLRB's authority. Here, our argument is that FINRA's rules exceed the authority of the SEC, exceed the authority of FINRA, which derives its authority from the SEC, because they provide the limitations that I addressed before. They preclude parties from agreeing to resolve disputes individually in arbitration.
But is that distinguishable from Epic Systems? Because they're not saying you don't have to arbitrate. This is just about forum selection, right?
No, it's not.
That seems like a different kind of limitation, and I wonder if it's as absolute as you say about that.
The issue here is the enforceability of FINRA's rules. And FINRA's rules are crystal clear, as we addressed in our papers, that they prohibit FINRA members from entering into agreements that require individual resolution of disputes. They prohibit FINRA members from agreeing to resolve disputes in the form of their choice. And so in that... Right,
I'm just saying those types of restrictions are not addressed by Epic Systems and other cases, are they? These are different in kind is kind of what I'm trying to
I don't agree with that, Your Honor. Mm-hmm. The Supreme Court's FAA precedent, including Epic Systems, is clear that unless there's an express congressional command empowering the agency to limit the right to agree to arbitrate in any way, that such limitations can't be imposed. And so that's what the Supreme Court has held, not just in Epic Systems, but similarly in Italian Colors and with regard to the securities laws in McMahon, Rodriguez.
Is there case law that says any kind of limitation, that we treat all limitations the same? Because to me, it seems a little different to say you can arbitrate all you want. You just have to do it in this forum.
I guess I would say all of the cases. That's what every case. The court in Epic Systems used the language that the FAA protects arbitration rights pretty absolutely. And I think it essentially, it
Including
says
choice of form.
where you want under the rules that you want.
Mm-hmm.
And so that's what is at issue here. And it's especially at issue with regard to individual arbitration.
So did Epic Systems involve one form of arbitration versus another?
Epic Systems prohibited,
Litigation,
Epic Systems involved a prohibition
right,
on arbitration.
right.
And so
I mean,
same
the
here
alternative there was court litigation, class action, but court litigation.
with regard to class actions. That's
Right.
right. And so
And then-
here we have the same restriction. Here we have,
But it's arbitration versus arbitration.
not with regard to class actions, Your Honor.
So, well, I mean, it's a little confusing to me that what the FINRA one means, whether if there's already class action going on, you pull people out. But put that aside for a minute, because you said you have a facial challenge here and that all the precedent supports you, but the two cases actually involving the SEC, McMahon and Rodriguez, especially McMahon went out of its way to say that it was litigation versus SEC regulated arbitration procedures, right? It doesn't hold true for arbitration procedures subject to the SEC's oversight. Commission has expansive power to ensure the adequacy of the arbitration procedures employed by the SROs. They can regulate the rules adopted by the SROs. SEC regulates it relating to consumer disputes, including the power to mandate the adoption of any rules it deems necessary to ensure that arbitration procedures adequately protect statutory rights. I'm reading from McMahon on 233 and 234. So with it's and you had the same SEC approved arbitration procedure going on in Rodriguez. And so both times when you're talking about heavily regulated entities in an industry where the market depends upon relying on enforcement of rules for fairness, transparency, integrity in the market, the whole market depends upon it. Then when your argument is that precedent requires the SEC to stand down and allow brokers and dealers to create their own forum for adjudicating their own compliance with the law in suits brought by their customers. There's no precedent for that, at least as to these SEC cases. None whatsoever. And it seems to me, now maybe at the end of the day you'd win, but your whole brief and your facial challenge is on this is controlled. It's already answered by the Supreme Court. And I just see two Supreme Court cases saying we'll enforce arbitration as long, in a context where the SEC is providing supervision to ensure that the law is still complied with. So it seems to me, I don't understand, I guess, the argument that this is already settled.
I understand Your Honor's question, and I might make two principal points. I think the first point is that part of the the issue here relates to the way that the SEC chose to address the rulemaking petition and avoid this substantive question completely. So we don't have the SEC's position in the context of the rulemaking petition addressing this at all, and that. Going back to what I was saying previously, appears clear to be consistent with the SEC's consistent, persistent determination to avoid addressing that question. The second point I would make, Your Honor, is that the SEC's policy
You say
statement.
persistent, consistent to avoid. Have there been other petitions for rulemaking by other parties other than Thrivent raising the same issue?
Not with regard to broker dealers. In our opening brief, we addressed the SEC's efforts to avoid any final agency action with regard to the extent of authority to limit arbitration under the 33 Act.
Mhm.
And that was an issue that we explained at some detail in our opening brief, because it is consistent with the position that the SEC had been taking. But that gets to my second point, Your Honor, which is, I believe, crucially important with regard to Your Honor's specific question on this issue of oversight, because the SEC did, as we explained in our policy, in our reply brief, issue a policy statement which is binding on the SEC as a regulation 2 days after we filed our response brief. After the SEC filed their brief in this court, where the SEC concluded in the policy statement unequivocally that the Exchange Act, in the context of issuer investor arbitration, does not include any congressional command that would empower the agency the commission in any way to limit arbitration rights. And in footnote 39 of that policy statement, the SEC expressly addressed the point that Your Honor is asking about as far as agency oversight. The SEC in that footnote said it would be inconsistent with subsequent Supreme Court decisions to look at this question of oversight. The SEC acknowledged that Supreme Court precedent in the 3 decades since McMahon and Rodriguez looks simply to whether there is a clear and manifest indication to limit arbitration rights.
Are you saying we shouldn't follow McMahon and Rodriguez anymore?
I'm saying that McMahon and Rodriguez hold that the securities laws do not contain an express congressional command that's necessary to limit arbitration rights. The SEC acknowledges that.
There's an awful lot of explanation there as to the careful context in which they made that decision. That is SEC supervision of the arbitral process, and for obvious reasons. Again, and this is not directed at Thrivent in particular at all, but you can imagine great concern about sort of fox guarding hen house. I'm not suggesting Thrivent's a fox, but if it works for you, it works for everybody with your facial challenge.
I understand, Your Honor, and I think the important point there is that the SEC in their policy statement expressly disclaimed the importance of that analysis. They said that no subsequent decision has referred to oversight as a factor, and so the SEC has now said that 33 Act claims
haven't been subsequent ones.
Well, but the commission expressed its legal view that issuer investor claims can be arbitrated without any oversight. They said there is no oversight.
Refer to the SEC's reading of Supreme Court precedent.
I understand that, Your Honor, and that again gets back to the posture that we find ourselves in, where the SEC avoided addressing this substantive question entirely.
Right. I get that point. This is not affected by my question, but I'm trying to understand the nature of your challenge here as a facial challenge to FINRA's rules.
FINRA's rules.
And what year did the SEC approve those rules?
I don't have
It was 2007.
I think that yes, that's right.
Challenge within 60 days of that decision.
So at that point in time, there was
Arbitration Act had been around an awfully long time.
Right, and so at that point in time, my clients weren't directly harmed by those rules, and so that's why we're bringing the rulemaking petition that we're bringing now.
Again, you have your argument about the content of their response, but I'm not sure how you can bring a facial challenge to FINRA rules of arbitration if they weren't brought within 60 days of the SEC's approval of those rules.
Well, I mean, a rulemaking petition has long been recognized as a vehicle under the APA to challenge the validity of existing rules. The Supreme Court, even as recently as Corner Post, recognized that option always remains available, even when a party might be time limited on a rulemaking
Well, the rules
challenge.
is applied to that party. That's what was going on.
Well, right, and so
That's an as-applied challenge as opposed. I'm just confused by your facial versus as-applied. If you just say, I want to challenge FINRA rules as applied to our agreement. It's different than a facial challenge to the rules across the board, which is, I'm kind of confused as to your position.
Well, I mean, Your Honor, I want to make one more point that I also recalled to your question about SRO oversight on arbitration. I think that also the Supreme Court's decision in Italian Colors speaks clearly to this, and Epic Systems do. It's not just a question of whether or not there is, I mean, they say there is no congressional command. those cases also address, so in Italian Colors, as I'm no doubt your honor is aware, the court addressed at length, could rights be vindicated for class members if there was no class action? And the Supreme Court looked at that and it determined that that was not a factor that it could consider in the context of determining whether or not antitrust claims could be required to be arbitrated individually and not subject to class treatment. The court held that the question is, and the only question is, has Congress spoken in a way that arbitration rights are limited, period? And so the court said there's no congressional command empowering, limitation of arbitration rights, and that is the test. Similarly, in Epic Systems, the NLRB argued about its authority to protect workers' rights and to oversee that. And the court, again, held clearly that the question is, does the statute, by its terms, include an express command empowering the limitation of arbitration rights? So that is consistent with what the SEC recognized. I understand that the court is not bound by the SEC's interpretation of Supreme Court precedent, but they're acknowledging the point that I'm making here that we made in the
All those
rulemaking
cases
petition.
didn't involve the SEC, where we have two cases from the Supreme Court that approved arbitration only when it was regulatorily supervised arbitration. That is that the regulated party could not have a contract with its customer to decide who would decide whether we have complied with the law. I'm not saying what's what we do today or tomorrow, what they would do
Right.
with those cases. But we as lowly Court of Appeals have that sort of precedent staring us in the face that makes this at least a much more complicated question. For purposes of your facial attack here, that's separate from your argument just about the content of their response to your rulemaking.
Understood, Your Honor.
Can I ask you, I had one other sort of procedural confusion question. So my understanding from your brief is that you've presented to the SEC your agreement, in your registration statement, and attaching your customer agreements that contained these arbitration terms, said not FINRA arbitration. And then the SEC, I guess, did not act on those, which meant in that context, they were approved by the SEC, and action equals approval by the SEC.
They went effective. That's right, Your Honor.
They went effective.
Yes.
Right. And so are you using those? Have you been using those customer agreements since they became effective?
No, we have not. And we addressed that because FINRA, and this was expected.
You went to FINRA after.
Correct.
You went to SEC first and then
Correct.
FINRA. Did you tell FINRA that the SEC had already approved these?
Yes, Your Honor, we did.
Okay.
And so this is in the rulemaking.
This was really confusing to me.
Yeah, this is in the rulemaking petition.
Mm-hmm.
But that's absolutely and exactly what happened, is that these registration statements went effective. And then my clients engaged with FINRA and said, we now have these registration statements. We would like to be able to sell them and market them, and engaged in a dialogue with FINRA, and FINRA said, well, that would be a violation of our rules.
So you're using registration statements that were not approved by the SEC?
No, those registrations, there are other registration statements. I mean,
So
my client has a wide range of
well, as to these, the very sort of life insurance securities.
the variable products.
Here,
Yes.
I assume that as to the ones that issue here, those are the ones that were approved by the SEC, by silence, but approved. I'm just going to call it approved by the SEC. And then later rejected by FINRA. And so you're using
Other variable products that have also gone effective that do not have the mandatory aspect of.
And you're able to
dispute.
use the same registration statements for different products, even if the SEC hasn't approved them for
Yeah,
that
they've-
specific product. Okay.
They've all the registration statements that are being marketed and sold have gone effective, have gone through SEC registration.
Okay, so we have this one the SEC has signed off on, but the FINRA then said,
Correct.
we beg to differ.
Correct.
Okay, all righty.
And again, Your Honor, I do want to emphasize, though, that, I mean, that is a necessary aspect of our being here today as far as having standing and being harmed by these FINRA rules. But again, this is a rulemaking petition challenge to the validity of those FINRA rules that don't depend on the contents of particular.
Why isn't it, all right, why didn't you seek SEC review of FINRA's decision?
When it said you can't use these registration statements, that the SEC had already said you can.
Well, so I guess it's two separate questions, right? One is registration of product under the 33 Act, and then the other is whether or not they can be marketed and sold. And so the challenge.
Could you have gone to the SEC? FINRA said no.
Well, I think that goes.
SEC, you just said, yes, please resolve this problem for us.
Judge Millett, I understand your question. I think that goes to the fact that we're now on 4 years since we filed a rulemaking petition with the SEC.
I'm asking a procedural question.
Well, no, but what I'm saying is we had informal conversations with FINRA about this, and
you don't have a final decision from FINRA?
we have FINRA provided us with a letter that it would be a violation of their rules to market and sell these products.
So that doesn't sound like an informal discussion. That sounds like a final decision by FINRA?
No, there was no formal adjudication process that we went through with FINRA. We engaged in extended dialogue. We took the route that would present this question to the SEC because the SEC has the responsibility to approve and oversee FINRA and make sure that its rules are consistent with federal law. So to the extent that the question is whether or not the rules are consistent with federal law, we filed the rulemaking petition with the SEC. And my point on the 4 years is that even doing that took us 4 years. And so to the extent you're asking about a preliminary process with FINRA where, FINRA may have a different view on the enforceability on federal law. We filed a rulemaking petition with the SEC, which is absolutely an appropriate vehicle to raise the invalidity of federal rules. And so even that has taken us 4 years to get to where we are right now.
Well, if it turned out that the Hobbs Act limitation period bars your facial challenge to the FINRA rules or SEC's approval of the FINRA rules, then how could you take the letter from FINRA to the SEC and either just directly ask the SEC for action review of that, or not? Is the only way to get to the SEC through an adjudicatory process at FINRA? That's my first question. And then the second one is, why couldn't you do a petition for rulemaking that focused solely on the FINRA decision in your case? If you can't go directly to the SEC from the FINRA letter, why wouldn't your petition for rulemaking have to be confined to FINRA's action on your particular registration?
I'm sorry, I'm not sure I heard the last part of your Honor's question.
I'll try it one at a time. I'm not being fair when I ask so many questions at once. So you got this letter, you had discussions with FINRA, and FINRA says, or somebody in FINRA says, we don't think you can have that. No, you can't. If you have those provisions in your customer agreements, they will violate FINRA rules. What recourse do you have from that? Is there any recourse from that? Can you appeal to FINRA board, or can you go to the SEC at that point?
I don't believe that there was final FINRA action in the sense that we hadn't taken steps that would be required. It hadn't gone to the FINRA board. And so I don't believe that without going to the FINRA board, it could be something that we took to the SEC.
But
But
if you
again,
went to the FINRA board, then you could go to the SEC.
that's my understanding,
Okay.
Your Honor.
So we don't even have a final decision from FINRA in this case.
No, but Your Honor, this is a rulemaking petition challenge. First off, the SEC hasn't made any of these arguments, and I do think that that's an important point of emphasis here. That there's no argument that
Exact time limitation, is it jurisdictional or no?
I don't believe so, but I think, let me correct that. I believe that the Hobbs Act is, but here, this is a rulemaking petition challenge. And again, I would direct Your Honor's attention to Corner Post, where the court addressed.
Corner Post involve the APA, not the Hobbs Act.
And this is we have an APA challenge here,
It involved the APA's statute of limitations, not the Hobbs Act.
but there's no, but there, the
There's
court,
a statute of repose,
right, and
the APA statute of limitations was held not to be in Corner Post.
I understand that, Your Honor, and
So
that's,
if it's a statute of
but,
repose,
right,
then
but
it's
that's
fine.
where
Big
the court
question.
said, even if the dissent was correct,
Mhm.
a rulemaking petition challenge to the validity of regulations is always there.
As applied,
I'm sorry?
as applied.
I don't understand that to be a distinction. We haven't seen that in any rulemaking petition challenges where it's an as applied challenge as opposed to a challenge to the validity.
Is Corner Post not challenging the application of the regulation to itself?
Corner Post absolutely was, but my point is that the court in addressing the dissents.
I guess the point is that if you can just bring facial challenges whenever, then there's never any either limitations period under the APA or repose under the Hobbs Act.
But that is consistent with the APA's rulemaking petitions case law. We haven't seen a single case that holds that a rulemaking petition is prohibited because it wasn't brought within 60 days. That's the purpose, is that Congress provided a vehicle for parties to challenge the validity of existing rules through a rulemaking petition challenge. And absolutely, the court addresses there that, the standard of review may be deferential, but it's there.
A rulemaking petition is different from a challenge to validity. It's an argument that you should change your rules because of your validity.
Of which validity, and so Geller, going back to the court's decision in Geller, that was absolutely,
I understand that, but
right, but that was absolutely,
different.
but that was a challenge to the validity of the rules.
Right. No, I completely understand that. But then, I mean, it's just, it's asking you agency, super broad discretion to change it because of this, right?
And
On validity.
well, so that gets to the plain error of law that the court has found to constitute compelling circumstances to vacate a rule when rules are premised on plain errors of law. And so even the standard, Your Honor, that this court has articulated in the first Flyers Rights decision, in American Horse.
The problem with plain errors of law is that you've got two Supreme Court decisions involving arbitration in the very SEC context we have here that focused on the fact that that involved and focused on in McMahon, the fact that it was SEC superintended arbitration.
That's right. And then we have the subsequent cases.
Okay, but then we've already done this. I don't mean to rehash it.
Right.
I'm having a little trouble with your plain error of law argument here, but anyhow.
Well, but Your Honor, to that point, I do believe that I mean, when the court's standards talk about the agency being blind to the source of its delegated authority, the court absolutely doesn't owe deference to the agency's legal interpretation in the sense that Wilbur Bright makes that clear. But where the agency says, as they did in their policy statement, that this factor that the court looked at in McMahon is not a factor. And they've now actually adopted a regulation with regard to issuer investor claims that can be, you can put an arbitration provision in a registration statement as a result of their policy statement. And so their view here is relevant. That is their view that what the court, that essentially that was dicta in McMahon and Rodriguez, that it's been superseded by the court's own standards in Italian Colors, in Epic Systems, where agencies made the same arguments. The NLRB made effectively that argument that they had a charge to protect workers under the Labor Relations Act, and the court rejected that. That said, the only question is there an express congressional command? And in the National Labor Relations Act, there's not, which is what the court in McMahon and Rodriguez also addressed in with regard to the 34 Act. And so in that sense, I do believe that the commission's policy statement on this point is crucially important.
Why don't we, we've talked a lot about the commission.
Yes.
Unless there's further questions from my colleagues, maybe we'll hear from commission counsel.
Okay, can I just ask?
Yes.
Does your position then depend or turn upon this plain error aspect? Because I guess I'm thinking about the rule we would be creating here, because it is a very deferential standard of review, like when somebody petitions for an agency to change their rules, we want to give a lot of deference to the agency in picking and choosing like what rules they take up. And I just want to understand, are you asking us to hold that because this is a plain error and it's clearly and obviously something that's wrong, therefore there's an obligation to address the merits of that? I'm just trying to understand how this fits within our case law that says you're deferential, they can rely on resource concerns and discretion, et cetera. And is the distinguishing factor that it's a plain error of law?
Judge Penn, I understand your question. I think I want to try to break that down between the two ways in which we contend that the SEC abused its discretion. Because the first is the response that the commission gave here, it just plainly doesn't satisfy its obligations.
Yes, let's put that aside for a
yes, no, but I understand that. But
I'm
here,
asking for like, what's the legal principle that we would be announcing?
So the legal principle there is that absolutely, as part of a reasoned response, the agency needs to address the merits to some extent. And so here, our contention in the rulemaking petition.
Would it be enough to say they claim this is a plain error? We don't see it that way. We think it's unclear and we don't have the resources to work that out right now.
Well, at that, I suppose that to the extent they say they claim it's a plain error and we don't see it that way, that would I mean, so here they argue, right? And they argue, well, we haven't addressed, they identify what the legal question is. Like their statement of the case, their counterstatement of the case, they understood that the rulemaking petition was presenting a facial challenge, and then they try to reframe the argument as a battle between.
But I guess the reason I'm asking it this way is because any person petitioning for a rulemaking can say, this is a plain error of law. It's got to be fixed. And I don't think that that can be the governing standard for requiring the rulemaking to happen. So if it's sufficient to say, they allege it's a plain error, we don't see it that way, and it's going to take a lot of resources for us to figure this out, and we don't have the resources, would that be sufficient?
Well, I suppose they would need to explain the extent of their resources much more than they did here, consistent with Wild Earth Guardians.
Right, but in terms of the legal
in terms of the legal standard, in terms of the legal standard, then that would be a different question before the court.
But it would be sufficient for an agency to say that?
Well, so I don't think, first off, I don't think we're asking the court to create any new standard here. The court in Geller made clear that where...
It feels different to me because you're trying to say that this agency has to consider your petition for rulemaking because you say it's a plain error of law.
No, we're saying that the agency has to, I mean, there are due process, has to consider any rulemaking petition. There are due process implications here, absolutely, where a legal challenge is being made. So, you know, the procedural posture that we're in is that either we bring this rulemaking petition challenge or we bet the farm by risking sanctions.
You appeal to FINRA's board, and then you take that decision to the SEC. You got
But-
process here, other processes here.
Well, but either way, you end up back at the SEC. And so
But then you end up in the SEC, before the SEC in a very different posture than a rulemaking petition.
And you could win before the SEC.
The SEC,
Well,
SEC's already answered that question. It's easy.
Okay, so, but again, this goes to where it took us 4 years to get here. And it's not apparent, we're talking hypotheticals.
We could have gone on both tracks.
And
They aren't exclusive.
I understand, Your Honor. I don't believe that changes the legal standards that are before the
I'm just
court. And,
responding to your due process concerns.
well, okay, so
You only had one or the other, and that doesn't seem to me procedurally accurate.
I guess I would say that what due process addresses, now we're talking about general standards for rulemaking petitions. And so to Judge Pan's question, to the extent there is a challenge to the validity of any rule in a rulemaking petition, it does present that due process question. And so here, if the agency denies it without addressing the merits at all, it does present a due process question as well. So, and it was interesting that was another point that we raised in our brief. The SEC chose not to respond to that. And so on your question, Judge Pan, the second aspect with regard to the second way in which the agency abuses discretion is that here it was presented with this compelling circumstance where the rules are inconsistent with
According to you, compelling.
Of course, according to us.
Yeah.
Right. And so, but also consistent with now the SEC's own policy statement.
Right. I just read our cases to suggest that they have a lot of discretion in saying, we don't have time to do this right now. We have other priorities, et cetera. And I'm trying to understand like where the merits come into this in a way that's not so burdensome.
So I suppose
It removes the discretion.
right. And Your Honor, I suppose that, for example, the Environmental Health Trust case speaks to that, where it talks about where the predicate of the agency's decision has eroded. So here we have a policy statement.
I feel like those cases are a bit different because it seems like in those cases, there was an actual fact that the commission said this could change and we're going to revisit this later. And then it did change and then they didn't revisit it later. I just feel like that's a little different here because like you're saying, this was the same fact all along.
Well, and so that gets to the development of the law. And so which the SEC also acknowledged in the policy statement that, yes, we had McMahon and Rodriguez. Since then, we've had Italian colors, we've had Epic systems. This is a point that the policy statement makes, that the law has gone even further to make clear that these rules are not consistent with federal law. And so in that sense,
That goes to whether or not it was plain error. I'm trying to understand.
right. And so, but it also goes, I mean, so a predicate, I mean, certainly a factual predicate of rules could be their legal validity. And so here, to the extent that subsequent Supreme Court precedent has made clear, as the SEC recognized in their policy statement, that there is no such predicate anymore, that there is no basis, that's where we are at this point in time.
My colleagues don't have additional questions for you at this point. We'll give you a little time for rebuttal.
Thank you.
Ms. Parise.
May it please the court, Emily True Parisi for the Securities and Exchange Commission. The commission reasonably explained its denial of Thrivent's rulemaking petition, and the denial should be upheld. The commission provided Thrivent with a brief statement setting forth the rationale for its decision, and no more was required under the APA or applicable precedent. Thrivent's suggestion in this argument, in this appeal, that the commission was required to address a specific question raised by its rulemaking petition, here whether certain FINRA rules are inconsistent with the Federal Arbitration Act, simply because Thrivent asserted that the relevant rules were unlawful under cases applying the FAA, finds no support in the law, and for good reason. It would allow the filer of a rulemaking petition to commandeer an agency's resources and priorities merely by making an assertion that a challenged rule is unlawful. That position is remarkably broad. It could open up agencies to campaigns that involve filing rulemaking petitions regarding every regulation an agency promulgated or approved, asserting the petition thinks the rules are unlawful. And under Thrivent's view, the agency would be required to address each and every petition by saying whether or not the agency agreed and why.
But do you think the SEC can respond to any petition for rulemaking by saying, this is just not our priority right now?
I mean, certainly the cases such as Wild Earth and others say that is a valid reason for denying rulemaking petitions. Here, of course, the agency said more than that. And
Didn't
of
say
course,
a lot more than that.
I mean, certainly it's not the longest document the agency's ever produced, but that's befitting the fact that denials of rulemaking petitions are decisions of agencies not to act. And all the APA requires is a brief statement of the
It
reasons.
just seems very bare bones. There must be some level at which it becomes too bare bones. And this just seems so general and, basically we're prioritizing our resources for other matters. We don't consider that arbitration was a priority. These rules have been in effect for a long time. I mean, it just seems so general. I mean, hypothetically, what if it really was a very clear violation or a rule? You don't have to mention that in saying why you're not going to address it.
I mean, I think if you're in a situation where it's as clear as like Geller or something, then maybe it might have been an abuse of discretion not to mention it. But as we explained in our briefs, we're far from Geller land. And so it was not.
Don't you have to say something when they are alleging that it's a plain error, a giant mistake? You have to say, we don't see it that way. Don't you have to just say something about the merits?
I don't think that there's anything in this court's cases, and the other side hasn't pointed to anything that suggests that just because they claim that it's plainly unlawful, the commission is required to entertain that specific legal question. All that's required is for the commission to say why it's denying the rulemaking petition so this court can discern its path.
But if you agree that it would be arbitrary and capricious if it were a plain error, it seems like maybe you should just say, it doesn't cost you much to say, we don't agree, or just something about the claim that they're actually making.
I mean, certainly the commission could have, but I still don't think this court's precedents require it. It may be running the risk.
Just, is it arbitrary and capricious to
It may be running the
ignore
risk.
what the merits were?
Sorry, I didn't mean to interrupt you, Your Honor. But
Is
it
it
may be
arbitrary and capricious to completely ignore what the merits were if the merits are allegedly extremely serious or important or clear?
I don't think it ignored the merits of the petition. It ignored the specific check.
How did it address the merits of the petition? Maybe I missed that.
Well, I mean, I guess it depends on what you mean by merits. I mean, it addressed
The claim that they were making.
It did not address the claim of unlawfulness that they were making. Yes, Your Honor. But there is nothing in any of these courts' precedents that suggests that that the agency is required to address a petition in a certain way, even when there is a claim of unlawfulness. The cases like Geller and those say that if it is in fact so clear, like in Geller, the regulation had been superseded and the agency just still denies rulemaking, that denial may be an abuse of discretion. But those cases don't say that, it was a denial just because the agency didn't address the question. There's no cases requiring the agency to address the rulemaking petition in a particular way. What is required and what the crux of what this court's cases have held is that there needs to be, the agency needs to explain why it did what it did so this court can review it. And here the agency gave several rationales, how long these arbitration forums had been in existence, predating the securities laws. It made 2 points about resources constraints. It said that these the reexamination of FINRA's arbitration forum has not been placed on the regulatory agenda, and also that resources and priorities are being used for other capital formation and protecting investors. And then it noted in particular the context here of the Section 19C process, whereas this is the commission sitting in review of FINRA's private rules, and the Section 19C process gives the commission discretion as to when to invoke 19C, which is what Thrivent's rulemaking petition was asking, which is a very resource-intensive process. In addition to requiring written submissions, it requires the oral submission of data.
Couldn't you give this letter to almost any, or some form of this letter to any petition for rulemaking? It's just really not tailored. It's, we have other priorities, we have discretion.
I mean, I certainly don't think the part about, it situates it in context of the FINRA arbitration forum, and that is specific to this.
Maybe I misread this. I thought that all it said about this specific petition was it's challenging rules that have been in effect for a long time. And then otherwise, it's really boilerplate. And I don't know, is that arbitrary and capricious to do sort of a form rejection that just says we have discretion here and we have other priorities and we're not putting it on the agenda? That all of that is really something you could say to any petition for rulemaking.
I mean, I don't think you can. I think there's the piece Your Honor mentioned. I think the 19C process wouldn't apply for all petitions for rulemaking. It would obviously apply to petitions for rulemaking in the 19C context, but that is a distinguishing factor. Certainly, the resources point could be invoked in a wider swath of cases, but I think you need to look at all the rationales together. And I think with all those rationales, this fits comfortably within this court's cases.
Comfortably.
I think
Can you name some other cases where such a bare bones rationale was upheld?
I think in Wild Earth, it was as bare bones as here, and I think Flyers Rights, it was as bare bones. I mean, there, it was just the decision not to institute, to deny rulemaking.
Wild Earth was more specific. It submitted evidence of its budgetary and staff constraints, explained it had mandatory rulemakings in progress. In light of the constraints, it puts prioritizing sectors that emit more air pollutants than coal mines. That's more specific than here.
I mean, here, the commission also pointed to, its current regulatory agenda. I mean, I think it's more specific there, but I think that has to do with the context of the rulemaking at issue. I don't know what more specificity, would be required for this kind of challenge, but I think
you could say, we're looking at other different FINRA things such as this, and this, and, we don't have the resources to look at other ones in this area. You could just say more than we got other things to do.
I think what was here is enough, but I just think to the point, that case involved evident, data and studies and other pollutants that are susceptible to that sort of comparison. I'm not sure there's a great comparison here. Just saying, I'm not sure.
I mean, you could easily have said, you're claiming that this is a, clear error. We don't see it that way. And it will take us a lot of resources to, work this out. And we don't have those resources right now. I mean, all you're doing is writing a letter. So it's not that resource intensive to say something more.
I don't think that these courts require that something more.
You keep saying that, but I don't see any case that has upheld something as bare bones as this. Even if we're not going to have rules that say you must address merits or whatever, it seems like you have to say something that indicates you've thought about this. And I don't see that here necessarily.
Respectfully, Your Honor, I think that if you look at the rules the commission gave at JA 91 to 92 in context and together, it shows that the commission considered the petition. It didn't address the question in the way Thrivent wanted, but certainly that's not required.
Can you tell me, what is your best argument for evidence that they considered this petition?
Well, the rule, they considered the petition. They didn't consider the legal question the petition raises, but to me, that's two different things. They're not required to address the legal question raised in the petition just because it's put before them.
I guess I'm kind of focusing on the letter that they wrote. And so what's your best argument for why that's adequate?
I think that the letter at JA 91 to 92 lays out several rationales that the commission gave for why it denied the petition. It said that the arbitration forum has been in existence for over 100 years, predating the securities laws. It said that it made 2 points about the resources. It said that revision of and reexamination of FINRA's rules is not on the current docket, and it said it was currently using current regulatory agenda and it was using its resources for other priorities. And then it noted the 19C context, and it went through how 19C is an additional layer of discretion because it says the commission may abrogate FINRA rules, and it's a particularly resource-intensive process. So I think when you put those together.
Sorry, does it say the resource intent? I didn't recall them saying, adding that additional line about, and it's a super resource intensive process.
It did not say that, but it invoked 19C. On JA 92, it invoked 19C.
Double discretion was sort of discretion squared or something was the only point made.
Yes, Your Honor.
It wasn't about the resources.
But implicit in invoking 19C, which the statute provides that in addition to written comments, it requires the oral presentation of data is additional resources.
The agency didn't say it was concerned about the 19C resources as opposed to 19C gives us another layer of discretion.
I think you can fairly read it. It's talking about resources and cites 19C. But again, that's just.
I want to make sure I'm reading it.
You are correct. It didn't draw that explicit.
Are you relying on a line that says resources and personnel are being used for other matters?
Well, that in combination with
Technical.
19C, yes. It didn't make,
Additionally, 19C gives us discretion.
right.
Okay.
It make the explicit point I'm making here that 19C discretion also involves additional resources because it involves the oral presentation of data and submissions as well as written submissions. But I think that's fairly encompassed by what the commission did say there. And I think that, again, that fits comfortably within this court's cases. I would like to just address a few points.
If an agency gets a rulemaking petition like this and simply responds with, we choose not to use our resources to address this issue. One sentence. Would that be sufficient?
I think that would be a harder case, but I think, which is not what we have here. I don't think it is precluded by this court's case law.
Not my question, so I'll try again. We choose not to use our resources to address this issue. Is that arbitrary and capricious for insufficient reasoned explanation, or is it sufficient under existing precedent?
I think it is a much closer case under existing
I'd
precedent.
like to know whether it is or is not under your view of what existing precedent requires.
Under my view, I don't think it is necessarily arbitrary and capricious, but I could see how it could be harder in that
Why is it
situation
harder?
to discern the agency's path. But I think we have,
Harder. It's just saying what your client said here.
well, it's,
We really do not count the number of words in deciding whether something is arbitrary and capricious. And so if what the agency said here is, we choose not to devote our resources to this issue. And here we are saying that same point 3 or 4 different ways. I don't know why repeating it matters.
yes, I don't think it is arbitrary and capricious for an agency to say, we are not going to take up this rulemaking petition because we're using our resources elsewhere. I think that is consistent with, Wild Earth and Flyers Rights and other cases.
And you think that would be so no matter how clearly correct the claim is that the existing regime is contrary to law?
Well, again, Your Honor, I think certainly there's the cases like Geller and some of the other cases which suggest that an agency can abuse its discretion if it ignores sort of a clear violation of law. In Geller, it was the whole premise of the agency's regulation was the FCC regulated in order to have Congress enact a law. Congress enacted that law. And so the whole premise for the regulation was gone, and the commission, or the FCC still didn't, in response to a petition for rulemaking, reevaluate its regulation. And
But I don't know that it came up in the context where there was, correct me if I'm wrong, but where there was an affirmative statement made that resources are being devoted elsewhere.
I think that was part of it, but I don't think that it was, I mean, there were several rationales given in Geller, but certainly I think that it could be arbitrary and capricious if there was clear legal invalidity, but we don't think they have come close to establishing that under the Geller, American Horse, and other cases. And so it is not, because we're not in the realm of clear, plainly unlawful or clear invalidity, however you want to phrase the legal test, because we're not in that Geller world. It was not an abuse of discretion
that
here.
if there's clear invalidity, then resources have to be devoted to it? Or could you still say, no matter how invalid it may be, our focus is elsewhere?
I think, as the cases say, if the factual predicate for the rule has changed, the commission at least has to consider it. Even in Geller and American Horse, they don't have to necessarily do the rulemaking. That's the courts did not actually impose rulemaking, but they said the commission at least has to consider it, or the agency at least has to consider it. So I think if we were in the clearly unlawful world, they wouldn't necessarily have to devote resources to actually do the rulemaking or take up the particular rulemaking petition at issue, but it was an abuse of discretion there to not even consider the question in some fashion, whatever fashion the agency determined best.
Why isn't the fact that the SEC approved these registration statements, including the attached customer agreements with the arbitration provisions, had previously approved them by inaction, but had previously approved them? Why doesn't that necessitate the agency sort of reconciling the conflict between its prior approval and at least some subcommittee of FINRA's disagreement.
So Your Honor, that's just a different,
Despite all the arguments about the Supreme Court cases.
right. That's just a different context. So
That's this context.
the context of allowing registration statements to go effective is a different context. What the commission is looking at there, that's under the 1933 Act, and it's looking at the disclosures in the registration statement, and the fact that it let the registration statement go effective doesn't, the commission is not evaluating or looking at FINRA rules or anything like that. It's simply a different context. It's a different process.
So you just need to educate me, because I'm not an SEC specialist. They attached to the registration statements, the customer agreements that said, there's arbitration, you will not have FINRA arbitration. Or that's not going to be the mandatory form of arbitration here. That's what they attached. When SEC approves that registration statement, approves something that specifically says we're going outside FINRA regulation world, it doesn't approve that?
But it's not looking for, it couldn't possibly be checking for consistency with FINRA rules, all of FINRA rules. That's not what the agency is looking at when it's looking at a registration statement. There are specific things the agency is looking at when it looks at whether registration goes effective. It's a disclosure regime.
Transparency, fairness, disclosure to customer. Sorry, do you look at transparency, fairness, disclosure to customers? What is disclosed to customers?
Right, but it's
Disclosed that we're going to have our own arbitration process to customers, but the commission wouldn't look at that.
that's just not part of the analysis of allowing the registration statement to go effective. It's simply a different context, Your Honor. And again, the time the commission was reviewing the FINRA rules was back when it went through the Section 19B process, which was, as Your Honor mentioned, for two of them in 2007. For one of them, it was 1989 for the three challenged rules. And that's when the commission is evaluating the specific FINRA rules and their consistency with the Exchange Act. That's through the 19B process. The registration statement's just an entirely different thing.
The SEC has not yet approved then this customer agreement, even though it technically was allowed to go into effect.
No, it has not approved the agreement. It has let the registration statement go effective, but that is a different, that is simply an entirely different event under the securities laws. It does not weigh in on the arbitration agreement in the bylaws attached to the registration statement.
You sure my colleagues don't have additional questions for you?
Thank you, Your Honor.
Counsel. Okay, we'll give you 2 minutes for a rebuttal.
Thank you, Your Honor. I want to address both abuses of discretion that we assert here. First off, on the first abuse of discretion, Judge Pan, I think your questions to my friend were exactly right. If this denial letter here passes muster, it's a playbook that any agency could use in denying any rulemaking petition without saying anything at all. They just say resources and personnel are being used elsewhere, and then they cite their statutory regulatory priorities like protecting investors, market, integrity, capital formation. That's not saying anything. Also, I would look at the court's decisions in like, for example, WWHT and Geller, where the court held that a rulemaking petition requires, if it's going to be denied, that the agency show them it gave a hard look at the relevant issues. Geller says that an agency can't sidestep reexamination of rules where there are abnormal circumstances suggesting that the rules may no longer be valid. Here, after the policy statement, there's no question that that's true. On the second abuse of...
Can we consider the policy statement? I mean, I take the practical point you're making, but
Yes.
Can we consider that since that is long after after it postdates the agency decision in this?
Well, I understand, Your Honor. And I think the point is that the policy statement recognized the force of the legal authority that we had asserted in the rulemaking petition. So from that standpoint...
we consider it or not, since it's postdates the decision we're reviewing?
Well, I don't
We
think...
cannot.
Right. I don't think in the terms of determining that the agency abused its discretion, I think that's clear in the first abuse of discretion already. But the point is, now what does the agency have to do? There's no question based on the policy statement now that on remand, the Geller is clearly met here, that there are circumstances that call for reexamination based on what the agency has recognized. And I think the other point there is that, Italian.
So but if we can't consider it, then we can't consider it.
Well, I mean, to the extent this court is going to give direction on remand, I think it's absolutely, it's an agency rule. And so to that extent, it's something that the court can absolutely consider as far as what the agency should and might address on remand. The second abuse of discretion, though, Judge Penn, your questions with regard to the plain legal error, that's the standard, of course, that this court looks at in determining that the agency abuses discretion. But when we're talking about whether, when the agency reexamines its rules, what standard should it be applying? Here, that standard is met and, implicated by the Exchange Act, which is, are these rules consistent with federal law? That's what Section 19B requires. That's what this court in Susquehanna has made clear, that the Exchange Act hardly envisions that SROs have rules that are not consistent with authority under the Exchange Act. And so the question is, should the agency reexamine rules to determine whether they're consistent with federal law? If we get back here on appeal, then the issue is, if they still fail to correct them, was that premised on plain error? If I could make one final point, to the extent the court is considering remand, the SEC's denial, which was clearly insufficient, was issued by the commission the day that this court ordered them to respond to our second mandamus petition. And so to the extent that we're now here on 4 years, to the extent there is a remand here, I would encourage the court to consider some sort of process where the commission has already essentially escaped mandamus proceedings for a year by issuing their denial, and my clients are being harmed every day that these rules remain in place. Thank you, Your Honors.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
It was already enough, and so you're under 2 days, understanding the concerns of the